No, that is why after 1 week we'll make the necessary.
Mr. D.K. Sharma,
Well, UK Goswami.
sorry, UK Goswami, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Earlier.
My lord, I beg to mention an anticipatory bail application. We have filed it yesterday, my lord. Your lordship have already granted interim bail to the co-accused. Now the police is bothering me a lot. Tomorrow, my lord.
Day after tomorrow.
My lord, my lord. I'm grateful, my lord.
Made to your lordship. Lordship, I beg to mention item number 17, my lord.
Yes.
The can it be on 17th of this month, my lord, on Tuesday.
On request of Mr. A. Lal and counsel for the petitioner, let this case be listed on 17th of September 2007.
I'm okay.
Lordship, this is motion matter, Lordship, last listed on 18/8. On that day, the order was to list after 2 weeks. It has not been listed. Day after tomorrow, Lordship. Deeply obliged.
I beg to mention item 13, my lord.
30.
No, 13, my lord.
Yes.
I am for the respondent, my lord. Matter may kindly be taken some other day, ma'am.
You have informed the petitioner.
I will inform, ma'am.
No, first you inform. We'll allow your prayer when the matter is called.
I undertake to inform, my lord.
No, no undertaking.
My lord.
Because I have bad experience.
My lord.
May I please, your lordship? Lordship, I beg to mention for listing of one bail application, Lordship. The connected case, Lordship, fixed on tomorrow, Lordship, as item number 25 and 26, Lordship.
Tomorrow.
Tomorrow, Lordship.
Okay.
Arising out of same FIR, Lordship, they filed and which is listed for.
Okay, now.
Deeply obliged.
May I please your lordship? I beg to mention item number 7, adjournment for a day, lordship. Item number 7. 7.
What is your name?
RL City on behalf of T City, lordship.
Heard Mr. R.L. Sutia, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
May I please, your lordship, I beg to mention listing on for tomorrow, my lord. I have filed this yesterday, my lord.
What is the matter?
For tomorrow, my lord.
No, what is it? Bail or
Anticipated bail application.
regarding for offense punishable more than 7 years?
Above 7 years, Lord.
Okay.
Lordship, another prayer, Lordship, for listing of IA, Lordship, in connection with criminal appeal, Lordship. For
Criminal appeal, there are other senior courts.
Deeply.
May I please, Lordship? Lordship, I beg to mention item 38. 38,
38.
Lordship. Adjournment for the day, Lordship.
38,
Lordship.
CD is available.
Why are you seeking adjournment? CD is available.
38.
We'll take it up when the matter is called. When the matter is called up, we will take it.
Adjournment for the any other day, Lordship, any other day. Lordship.
Why?
No, my colleague is
Mr. What is your name?
A. Rahman, Lordship.
Mr. A. Rahman, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Learned additional public prosecutor submits that the case diary in this case diary has already arrived. Stop. The prayer for adjournment is allowed. Let this matter be listed in the next week on a date to be fixed by registry. The case diary may be retained till next day.
Of life, Lord.
Yeah, your lordship, I beg to mention item number 34. It's a bail hearing matter. The matter may be passable for the day.
You have to mention reasons also while mentioning.
Seniors, legs.
Okay. Is an interim, lordship. CD is not available.
Okay. Heard, Miss. What is your name?
K-tile.
Ketai, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Then an additional public prosecutor submits that the case diary which was called for has not arrived and seeks some more time to produce the case diary. The prayer is allowed. Let this matter be listed again on 23rd
23rd.
of September for case diary. The interim order shall continue till next day.
May it please your lordship, I beg to mention for listing of a criminal petition.
Other courts, senior courts like that.
May please your lordship, I beg to mention item number 25, your lordship.
Yes,
The city was called for, but the city has not arrived. I was informed.
25,
25.
city is not available.
heard Mr. What is your name?
TK Das.
C.K. Das, learned
Your
counsel.
lordship, TK Das.
T.K. Das, learned counsel for the petitioner. Also heard Miss S.H. Bora, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed again on 25th of
Lordship, on 17, your lordship.
when?
Lordship, can it be on 20th, lordship?
On 20,
Any earlier date, your lordship.
29, 2024.
My pleasure, Lordship. Lordship, I beg to mention for item number 12, Lordship. Lordship, due to some difficulty in IC of my senior, he is praying for an adjournment also.
You have informed the other side.
Lordship, I tried to contact, but they did not receive.
Wait for your turn when the matter is called up.
May please, your lordship. My lord, beg to mention item number 30 and 31, my lord. My lord, in this matter, case diary is available, my lord. However, my lord, due to personal difficulty, my lord, I pay for an adjournment.
City is available. lordship.
Mr. What is your name?
PH score, my lord.
PH,
PH score, my lord. I'm paying on
P-
behalf of Miss P. Bora.
PH Kumar, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Learned additional public prosecutor submits that the case diary has arrived. Stop. Let this matter be listed again on next week. On 17th of September, the case diary shall be retained till next day.
Lordship.
Oblige me.
May I please, your lordship. Lordship, I beg to mention for listing an anticipatory bail application for Friday, my lord.
More than 7 years.
More than 7 years.
Okay.
Oblige me.
May I please, your lordship. My lord, I beg to mention this matter for listing, my lord.
What is the matter?
Matter, my lord, it was last listed on 15/5/20.
What is the matter?
Matter, my lord, the writ petition criminal, my lord.
Senior court. Other courts are there.
Senior
Bye.
Wait, please, your lordship. I beg to mention item number 9, your lordship. In this matter, Mr. R. Kalita is engaged. So this matter may be kindly listed before any other appropriate bench, your lordship.
Okay. List this matter, item number 9, list this matter before any other bench without me, within bracket my name.
Hello.
May please, your lordship. Look, lordship, I call for the case diary, lordship, at this stage.
Heard
It's
Mr.
from
A.S.
first
Munir,
number.
also heard Ms. S.H. Bora, call for the case diary, fixing
On 19, lordship.
19-9 for case diary.
Much obliged, your lordship. Much obliged.
But here the petition, the FIR is at page 25. This application is moved by the accused number 1. Allegation is misappropriation of fund of a tea state, that is Nirmala tea state.
We
Station
will
in
call
Malad.
for the case diary.
But here, one thing I would like to submit, my lord, he is behind the bars since 1/7/2024. Today it is 75 days. On my lord 3/9, the bail application was moved. On that day, my lord, after expiry of 65 days. On that day, my lord, because of addition of my lord one new section, that is 413, habitual offender, my lord. For that reason, my lord, the bail was rejected. Otherwise, my lord, he has already completed the 60 days for other sections, my lord. It was added on, my lord, 23/7.
No, therefore we have to peruse the
Yes, so
case.
my lord, I pray my lord, before 90 days, at least my lord, the
Okay.
date may be fixed. my lord.
Heard Mr. B. Gogoi, learned counsel for the petitioner, also heard Ms. S. H. Bora,
90 days to the.
learned additional public prosecutor. Call for the case hearing.
Sir, what
When?
On 19, Lordship.
19th September for case hearing.
Thank you.
Well, here, my lord, in the other case, my lord, it is accused number 3, but here I would like to make one submission, my lord.
Same case, same
Same
paper.
case, but lordship may kindly see page 27 for a moment.
No, let us fix it on 19 after.
No,
page.
even in my lord, I just one submission, my lord.
Okay.
One submission. Page 23, page 27, this is the order dated 23/7/24, passed by the my lord learned trial court against the bail application. Just one order, my lord, part of the order I want to point out.
Yes,
The case record is put up today on the strength of prayer made by the investigating officer so and so, whereby he has prayed for allowing him to add section 413 of IPC in the instant case on the ground that according to NAFIS hit report received from the State Fingerprint Bureau of Assam, it has been revealed that the accused person, namely Pankaj Tiwari, is a habitual offender. Now, Lordship will kindly turn to page 34 of the same order, page 34, it continues. Pankaj Tiwari is accused number 1, the petitioner in the earlier item. So, 413, page 34. The last line in the first para. Moreover, as per so and so hit result, the accused.
what
Pankaj
is
Tiwari-
this NAFIS?
For the first time I have seen it, some bureau
You,
fingerprints and
you
all.
find out the meaning, next time we'll decide.
Well, by this time, why I'm saying is, specifically says, it is against the accused number 1. Only accused number 1. He is the accused number 3. Considering the other sections, it is statutory period is 60 days. On the day, when the bail application was rejected, the Honorable Trial Court missed this part, Ultimately, my submission will be, this is a miscarriage of justice so far as the present petition is concerned. He ought to have been granted a bail, statutory bail.
What are the other sections?
Yes.
What is 413 habit?
Habitual offender, there, the imprisonment, punishment goes to lifetime imprisonment also, beyond 7 years. Lordship will find the sections at page.
Okay.
That's
He
my
is not,
guess.
he is not habitual offender.
These are
413 does not come against him.
Lordship.
Heard Mr. B. Gogoi, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Mithilesh Tiwari, who has been detained behind the bars since when?
1/7/24.
Since 1/7/24. How many days have?
By now, today is 75 days.
Since last 70, within brackets, since last 75 days. In connection with Harlem PS case number 46/24 under section 120B/171E/379. Verify the other offense. Again, other offenses,
Yes.
what is the maximum punishment
It is 7 years now.
for all other offenses?
Yes, because of 413, in fact, I have mentioned it before this honorable court. Otherwise, other sections.
379/406/420/468/471/413 of the Indian Penal Code. Learned
IPC code.
the gist of accusation
171.
in this case is that on first day of July 2024, one Abhijit Roy, Director of New Manas Tea Estate Private Limited, Harlem, had lodged an FIR before the officer in charge of Harlem Police Station against four accused persons, including the present petitioner, alleging commission of offense under section 120B/179/406/420/468/471 of the Indian Penal Code. So, learned counsel for the petitioner has submitted that all the for none of the above mentioned offenses, the maximum punishment is more than 10 years. More than 10 years. However, he submits that on on 23 when this
Well, on 23/7, it was added.
on 23/7/2024 on an application made by the investigating officer to the effect that one of the co-accused, namely Pankaj Tiwari, is a habitual offender and has been involved in similar offenses in other cases. Section 413 of the Indian Penal Code was added. The offense for what is 413?
Three habitually dealing in stolen property.
Yes.
The offense under section 413 of the Indian Penal Code contains a punishment which may be extended up to life imprisonment. Stop. Hence, the maximum period of statutory detention for the said offense is 90 days. However, learned counsel for the petitioner has submitted that apparently section 413 would be applicable only against the co-accused Pankaj Tiwari, and it would not be applicable against the present petitioner Mithilesh Tiwari, who has been detained behind the bars for last 75 days, that is 15 days more than the statutory maximum statutory period of detention for which he could have been detained under section 167 of the, what is the contemporary section of equivalent section of 127, 167 in BNSS?
Why not, that part? My lord,
Lordship,
167 or equivalent. That I will place.
167 IPC.
Then 8 equivalent section.
Bima, what is the last line?
167 equivalent.
139. 139, Lordship.
One 167 of the CRPC / 187 of BNSS.
167 CRPC.
One equivalent of 167 is 187. Verify.
My lord. No, CRPC. Well, 167 of CRPC.
CRPC.
Stop.
187.
187 stop. On perusal of the records, I have heard learned addition.
67 CRPC.
No, stop. I have heard to cut it off. On perusal of the record, it appears that there is the section 413 of the Indian Penal Code was added only because one of the co-accused, namely Pankaj Tiwari, is a habitual offender, and there is no such allegation against the present petitioner. Therefore, stop. Therefore, in the considered opinion of this court, the present petitioner ought to have been released on completion of statutory period of 60 days. Stop. In view of above, the petitioner, namely Mithilesh Tiwari, is allowed to go on bail of rupees 30,000 with one's surety of like amount, subject to the satisfaction of learned, which
PGM Biswanath.
CGM,
Vishwanath.
Chief Judicial Magistrate Vishwanath, with following conditions, condition number 1 and 2. With above observation, this bail application is disposed of.
My lord, so far as my lord, the latest rejection order is concerned, that was my lord rejected by addition session judge Vishwanath because of addition of 413. So I leave it to your lordship, either of the authority, my lord.
No, matter is pending before.
My lord, the lordship may see page 36, the last order, my lord, wherever the bail was rejected of the two petitions.
No, it is still under investigation.
It is still under investigation.
Then it will go to Chief
CGM.
CGM.
I am obliged. I am obliged.
May I please? The pre-arrest bail application, petitioner has been absolutely implicated on suspicion. Lordship will find the FIR case 15.
What is the offense?
Offense is registered under section 336(2).
What is 336?
It has been forgery.
Forgery.
Yes, ma'am.
And 337?
337. is,
Using forged document.
Yes, ma'am.
What is your submission?
My lord. Lordship will see page 15.
Yes.
Mary, seized by the District Legal Service Authority, Shivsagar, FIR. I would like to state that on 16/7/2024, it is found that Anupam Das, the present petitioner,
Who is Anupam Das? He is a
the
staff.
UDS. I'm reading, my lord. It is narrated, my lord. Who has been working as UDS.
Case diary would be required.
My lord,
Case diary would be required.
my lord, lordship will call for the case diary, my lord. The seized document, your lordship will see once.
Where
Page
is
18, my lord.
seized document?
Page 18, my lord. The alleged document he has purportedly forged, my lord. Page 18. This is the report, non-starter report, name of the applicant Manjit Bora, the date of application for pre-institution of mediation 1/11/2023, name of the opposite party so and so. Date scheduled for appearance of the opposite party 24.
You are reading page 18.
Page 18, my lord. This is the report, my lord. It starts from page 16. Relevant portion I am reading.
No, what do you want to show by?
But you will see that the document, from this document, apparently that report, non-starter report region, opposite party not appeared, the findings, my lord. From this document, apparently the petitioner, he cannot take any advantage of this, my lord.
No, question of advantage is not there.
Yes, my lord.
Question of forgery is there.
Yes, my lord, also see paragraph 8, I have stated, my lord. There
No,
are four employees-
which signature it is alleged to have been forced?
Yes, my lord.
This SS,
Yes, my lord.
SS,
My lord, District Legal Service Authority Secretary, my lord.
this signature is alleged to have been forced.
The initial signature.
No, but this is a serious allegation.
Absolutely, my lord, lordship will see the page 6, I have narrated, my lord. There are 4 employees in the office, my lord, 1 LDA, 2 PLV, paralegal volunteer, and 1 office PN, my lord. My lordship is aware that proving of handwriting, my lord, until and unless that specimen signature is obtained and it is sent for the expert, handwriting expert. It cannot be conclusively stated that one person he has forged the document. There are other 4 persons in the office, madam. And then the FIR has been pointing out only against me, madam.
Yes.
Let us
Don't-
call for the case study.
Case diary. Allegation is serious.
I
We will call,
absolutely, I appreciate,
we'll
madam.
fix a short date.
My lord,
We'll call for the case diary.
yes,
No interim.
I absolutely, my lord. But that proving of handwriting, your lordship is aware, my lord.
No,
Until
no,
and unless it is
let
sent
us,
for the
let
specimen.
us
It's an
peruse the case.
anticipatory bail
Because
application.
this may not be a harmful document,
Not
My
but he might have,
That is correct, my lord. But the law of proving the
Let-
handwriting, my lord, it says, my lord, until and unless the specimen is
yes. But
Examine-
let us call for the case diary. Heard Mr.
P. Hazarika.
P. Hajorika, learned counsel for the petitioner. Also heard Ms. S. H. Vora, learned additional public prosecutor. Considering the nature of allegation level in the FIR, perusal of the case diary would be necessary for considering the instant anticipatory bail application. Hence, call for the case diary.
Lordship,
Fixing next week,
it's from this Sipsagar, Lordship,
It is from
20,
20, Lordship.
20.
20
My lord.
for case diary.
How nice.
Oblige.
Make the lordship 482 application alleging under section 326 and 327 IPC. He says the lady minor, that is charge sheeted matter, charge sheet already submitted, and husband of the.
Charge sheet submitted.
Yes, charge sheet submitted.
Then you will receive summons from the court.
Someone received mine.
You appear before the court.
My lord, session tribal test, my lord, when I appeared before the magistrate, my lord, the apprehension is
Which
there.
one is session tribal?
326 and 307, my lord. IPC. I appear, my lord, I cooperate the trial, my lord.
No, but there is no apprehension of getting arrested. Now there is no apprehension.
Yes.
Now, my lord, when I.
Anticipatory bail application is maintainable if you have apprehension of getting arrested. Where is the apprehension?
Yes.
When I appeared before the magistrate, my lord.
Then what
Without-
magistrate will do, nobody knows. But now there is no apprehension. This is not a case under 438 and this 482.
So it's been already solicited, Lordship.
Charge sheeted case you have received. Yes, Miss Bora.
Should I call for the scanned copy of LCR?
Okay. Heard Mr.
F. A. Hassan.
F. A. Hassan. You have produced this copy of rejection order.
Yes, my lord. In additional affidavit, we have filed, my lord. Because it was a record on not my lord, so don't do it, but in our additional affidavit, we have to submit the additional rejection order, my lord. It's page 39. In our additional affidavit.
It's 39.
No, this is sub this additional affidavit.
We have to page in it. 39.
Now, additional affidavit.
No, we do not have the copy. Copy to 9.
From sub police.
9. I do make a rejection order.
No, we can reject it now also.
Yes, Lordship, because otherwise allegations are serious, Lordship.
Let the trial court decide.
Yes.
The observation will be trial court may be considered, my lord, to appear before the trial court. Someone received, we appear,
Okay,
and same may be considered, my lord.
okay. Heard Mr. I. Hussain,
F. A. Hassan on behalf of I. Hussain.
F. A. Hassan, learned counsel for the petitioner. Also heard Miss S. H. Bora, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioner Yasmin. You are a lady?
Lady, my lord. That
Yes,
is why, my lord.
Sultana.
Well, my husband was arrested and he undergone bail, my lord. So as a lady, my lord,
और appear before the trial court में जो कौन सी का bail
No, if you are a lady, then trial court can also grant you bail.
Yes, Lordship.
Because you fall within the exception of 437.
Yes.
Then there is no apprehension of getting arrested. What is the last line? Petitioner Yasmin Begum, who is apprehending arrest in connection with PRC case number 413/2024 under section 326/307/34 of the Indian Penal Code, pending before the Court of Learned Chief Judicial Magistrate Sonitpur. Stop. Learned counsel for the petitioner has submitted that the petitioner has received summons from the trial court and the next date is fixed on summons from the trial court. However, as the sessions tribal cases sessions tribal offences are involved, he apprehends that on his appearance before the said court, before the trial court, the petitioner would be remanded to custody, and therefore he has prayed for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has submitted that there is, as the petitioner has received summons from the trial court, there is no apprehension of her getting arrested in connection with the pending case. Stop. Stop. It appears that the petitioner has approached this court mainly because of the embargo of section 437 clause 1 within bracket small 1, where the magistrate court may not grant bail for an offense where there are reasonable grounds for believing that the accused has been guilty of an offense punishable with death or life imprisonment. However, the petitioner being a lady, the proviso to section 437 clause 1 may be applicable in her case, and therefore the committal court is not debarred from considering the bail prayer of the petitioner on her appearance before the said court. Stop. Thus, this court is of considered opinion that there is no apprehension of petitioner getting arrested in the PRC case number 418/2024 as of now. Stop. More so, because she has only received summons from the Court of Learned Chief Judicial Magistrate Sonitpur. Stop. The petitioner may pray for regular bail on her appearance before the learned committal court, and if such a prayer is made, same shall be considered by the learned Chief Judicial Magistrate as per law. With above observation, this anticipatory bail application is disposed of.
May it please your lordship.
Yes.
My lord, petitioner before lordship is a cashier, my lord, of the Grameen Vikas Bank, Dhola branch at Nagaon, my lord. My lord, allegations are set of criminal breach of trust, cheating, theft,
Misappropriation.
misappropriation, my lord. Here, my lord, I just want to point out one thing only. FIR seems to be allegation against me. It appears, my lord. But at paragraph number 3, I have explained
Where is the affair?
FIR it as page 16, my lord.
Yes. Now, what is your submission?
My submission, my lord. At para 3, I have tried to explain the situation, my lord. Actually, my lord, what has happened? One branch, at that point of time, one branch manager, I have stated the name also. My lord, since I am the cashier, I am bound to follow his instructions. What he did, my lord, I have stated that whenever a customer deposits an amount by way of a slip, deposit slip, what he does, my lord, he says to show it to be credited in the account of the particular customer, and that's against that slip. But the physical that money is not given to me, my lord, by the bank manager. I again and again requested him, many occasions this has been done. Then he said, I will just you just show it on record, I will give you. That for that reason, my lord, probably now it seems that I have misappropriated what man. Only thing, my lord, if this whatever I have stated is a fact, and if my lord allows me to appear before the IO, my lord, I will explain everything. And this particular Raju Doimari, he's again and again, I'm contacting him. He says that I will give you the money back. I have stated everything, my lord.
No, but being cashier, you have to deposit
Yes,
money every day.
That is true, my lord.
Every.
So
Therefore, case diary would be required.
my lord, that I have stated that whenever I try to praise him for the money, he is my senior, my lord. He always threatens me that I will do something that he will be removed from my job. My lord, can it be this way, my lord? And let my statements be recorded and these materials will be handed over to the IO. After that, my lord, if CD reveals, my lord, I have nothing to say, my lord. It will be on lordship. But I will lose my job if I, my lord. That is the thing, if I may state, my lord.
We are fixing a short day.
Yes, Lordship.
Case diary is perusal.
Because physical case has been recovered.
How much?
from
How much?
Lordship is amounting to rupees 11,29,470.
Not recovered, not recovered. It is
Physical case has been found. That has been found.
Found
So-
from whose possession?
Lordship, present petitioner also. It's from
Hey,
minor.
no.
Let us call for the case
Yes,
diary,
Lord.
fixing a short date.
No, nothing, my lord. Money is not recovered from me.
Yes,
Not
yes.
recovered.
During inspection, an amount of rupees 11,29,470 only
Yeah.
in physical case has been found. An interrogation, the cashier, namely so-and-so, the present petitioner, has stated before our staff that the inspecting officer that he has been intentionally misappropriated.
And
the false amount.
physical case has been found as deficit.
Where are you reading?
Lordship, the
Page.
Physical
page
case has been
Lordship
found as
16,
deficit.
FIR Lordship, third line Lordship, during inspection. And thereafter.
Found as deficit, my lord.
Lordship, during inspection, the third line, page 16.
Yes.
During inspection, an amount of rupees 11,29,470 only in physical case has been found as deficit, and on interrogation, the cashier, namely the present petitioner, our Lordship has stated before our staff that the inspecting officer has intentionally misappropriated the aforesaid amount. And thereafter, Lordship, but at about 3 p.m., he fled away, taking with him an additional amount of rupees 25,06,960 rupees, Lordship, which was found out during closure of business hours as well.
Case diary.
2 lakhs.
Heard Mr. T.H. Hajorika, learned counsel for the petitioner, Also Miss S.H. Bora, learned additional public prosecutor. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing when
23, Lordship.
23.
My lord, on 28th, Nagaon from Nagaon.
Let it
Monday.
wait, 20.
20 man.
Let it be on 20. 29 for case diary.
Deeply obliged.
Lordship, item 58 and 59, Lordship. With regard to item 27, it is there. That may be taken together along with when the 27. Also. 58 and
27.
59.
Okay.
Item 24.
24. Lordship, matter may be taken after some time. Senior counsel is engaged on another report.
Okay. Who is the counsel?
F4.
Okay.
Item 26.
Minus case diary not received.
Case diary not received. None appears for the petitioner on call. The heard Mr. P. Borthakul, an additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed
On 24.
on 24/9. Okay.
Item 27. Wait, please, Your Lordship.
Well, 27 and now my lord mention item number 58 and 59.
Yes. That's 27.
Let us take 27 first.
Yes.
Case diary is there.
Case diary received.
What are the offenses?
Offenses of gang rape, my lord. Criminal intimidation is also there.
The
Criminal.
petitioner is a subject server who arrested on 29/8/2024 in connection with the Dogri PS case number. So the FIR is at page 11.
Yes.
Can you take up the vernacular one, my lord? Page 18.
Next to amendment.
Yes.
Page 18. সম্মানপূর্বক বিনীত নিবেদন এই যে 1 নং আসামি জনে তাৰ প্ৰথম স্ত্ৰীৰ মস্তিষ্ক ঠিক নহয় আৰু পাগল বুলি আখ্যা দি তাইৰ লগত সংসাৰ নকৰো বুলি কৈ এজাহাৰকাৰীক নানা ধৰণৰ মিথ্যা প্ৰলোভন দি তাইৰ লগত 10/3/2023 আৰু 26/4/2023 তাৰিখত মেৰিজ এগ্ৰিমেণ্ট যোগে আৰু তাৰ পিছত 22/5/2023 তাৰিখত কাবিং ৰেজিষ্টাৰ যোগে বিবাহ কৰা। বিবাহৰ পিছত 1 নং আসামিজনে এজাহাৰকাৰীক বগৰীবাৰী আঙ্গাৰকাটাত এটা ৰুম ভাড়া লৈ তাতে এজাহাৰকাৰীৰ লগত 8-9 মাহ মান সংসাৰ কৰে। এই 8-9 মাহৰ ভিতৰত 4 মাহ মান ভালে ভালে সংসাৰ কৰাৰ পিছত 1 নং আসামিজনে এজাহাৰকাৰীৰ পৰা যৌতুক দাবী কৰি তাইৰ ওপৰত শাৰীৰিক আৰু মানসিক অত্যাচাৰ চলায়। আসামিজনে দাবী কৰা মতে যোৱা 28/5/2023 তাৰিখত 50,000 টকা আৰু তাৰ কিছুদিন পিছত 3,50,000 টকা এজাহাৰকাৰীয়ে তাইৰ দেউতাকৰ ঘৰৰ পৰা আনি 1 নং আসামিজনে দিয়ে। তাৰ পিছত 1 নং আসামিজনে বাকী আসামিজনৰ কুবুদ্ধি আৰু পৰামৰ্শ মতে আকৌ এজাহাৰকাৰীৰ পৰা 50,000 টকা দাবী কৰি তাইৰ ওপৰত অমানৱিক অত্যাচাৰ চলায়। 2 আৰু 3 নং আসামিজনে এজাহাৰকাৰীয়ে ভাড়া ঘৰত অকলে থকাৰ সুযোগ গ্ৰহণ কৰি কেইবাবাৰো উক্ত ভাড়া ঘৰত গৈ তাইৰ অশ্লীল প্ৰস্তাৱ আগবঢ়ায় আৰু সিহঁতৰ লগত অনৈতিক কাৰ্যত লিপ্ত হ'বলৈ হেঁচা প্ৰয়োগ কৰে। অন্যথায় 1 নং আসামীৰ লগত এজাহাৰকাৰীক সংসাৰ কৰিবলৈ নিদিব বুলি ধমকি প্ৰদান কৰে আৰু প্ৰয়োজনবশতঃ 1 নং আসামীজন 2, 3, 4 আৰু 5 নং পঠাই দিব বুলি ধমকি দিয়ে। 2 আৰু 3 নং আসামীদ্বয়ে তাতে ক্ষান্ত নাথাকি উক্ত ভাড়াঘৰত এবাৰ এজাহাৰকাৰীৰ ইচ্ছাৰ বিৰুদ্ধে জোৰপূৰ্বকভাৱে তাইৰ লগত শাৰীৰিক সম্পৰ্ক স্থাপন কৰাৰ
চেষ্টা চলাইছিল যদিও বেলেগ মানুহৰ হস্তক্ষেপত বিফল হৈছিল এজাহাৰকাৰিণীয়ে কোনো পধ্যেই 2 আৰু 3 নং আসামীৰ অনৈতিক প্ৰস্তাৱ গ্ৰহণ নকৰাত এতিয়া 1 নং আসামীক অজ্ঞাত ঠাইত লুকাই ৰাখিছে আৰু এজাহাৰকাৰিণীৰ লগত সংহাৰ কৰাৰ পৰা বিৰত ৰাখিছে 2 আৰু 3 নং আসামীয়ে সঘনাই সিহঁতৰ আগৰ অনৈতিক প্ৰস্তাৱ এজাহাৰকাৰিণীক আগবঢ়াই আহিছে আৰু ইয়াৰ উপৰিও যোৱা 17/7/2024 তাৰিখ মহৰমৰ দিনা দুপৰীয়া 12টা মান বজাত 2 নং আসামীজনে এজাহাৰকাৰিণীক 1 নং আসামীৰ লগত সংহাৰ কৰাই দিব বুলি কৈ ধুবুৰী নয়া মছজিদত থকা তেওঁৰ ভাড়াঘৰত মাতি আনি জোৰপূৰ্বকভাৱে এজাহাৰকাৰিণীৰ ইচ্ছাৰ বিৰুদ্ধে তাইৰ লগত শাৰীৰিক সম্পৰ্ক স্থাপন কৰে আৰু উক্ত কথা বেলেগ মানুহক ক'লে তাইৰ মুখত এচিড ঢালি দি হত্যা কৰাৰ ভাবুকি প্ৰদান কৰে প্ৰায় প্ৰাণ ৰক্ষাৰ ভয়ত এজাহাৰকাৰিণীয়ে উক্ত কথা তাইৰ মাকৰ বাহিৰে
কোনে কৰে
মানে
who sorry
the 21 number 1 nong এজাহাৰকাৰী 1
who
nong
is the husband
number 1 is
number 1 is the husband she is alleging rape against husband
no well here the alleging rape against the accused number 2 and
accused
3
number 2
2 is the brother-in-law of the accused number 1
okay 2 means Aminur Rahman
is the brother-in-law of the accused number 1
and accused number 1 Samshul is
the husband of the informant
so what happened on 17th
what had happened my lord here in this case
no
accused number the informant got married with a marriage agreement with the accused number 1 and subsequently she alleged that there is a dowry demand on the side of the accused number 1 and she lost several FIR my lord kindly just peruse page 28 the similar FIR lost against the husband
no in this FIR
my lord
the allegation of rape is against accused number 2
2 and 3.
2 and 3
who is 3
but 3 is also the brother-in-law of the accused number 1 accused number 1 earlier got married he has another wife my lord first wife and the informant is the second wife now the allegation leveled by the second wife earlier she lost another affair on 8/3/2024 wherein there is no such allegation against the accused number 2 and 3 and in that FIR the allegation basically alleged against the accused number 1 and his whole family members that there is a dowry demand and she also filed a domestic violence case
no but here the allegation is of later incident
but
in the month of July
yes but well kindly see the statement from the informant itself once in the page number 18 my lord she said 2 আৰু 3 নং আসামীৰ দয়ে ইজাহাৰকাৰীক ভাড়াঘৰ
চিঠিখন আহিছে নে
yes
Can I pray this matter will be taken up on Friday? I couldn't go through it. Friday,
okay
this matter.
heard Mr. K. N. Chaudhary, learned senior counsel assisted by Miss R. Kakoti, learned counsel for the petitioner. Also heard Miss S. H. Bora, learned senior counsel for the petitioner, has prayed for listing this matter on
Friday.
13th.
That is on 13th.
13/6. The prayer 13/9. The prayer is allowed. Let this matter be listed again on 13/9.
Obliged.
May it please the Lord. My Lord, the affair is at page 16, my Lord. Today, the OC Fatasil Ambari PS received information from the head constable Osini Kolita Police Reserve Guwahati that he went to the field of Tribal Development Authority located at about 100 meters from Fatasi Lambari PS and noticed that many vehicles seized by Fatasi Lambari police long before were found missing from the said field. Those seized vehicles were kept at the field as there was no space at Fatasi Lambari PS campus. Head Constable Osini Kolita knew about the said seized vehicles as he was earlier posted at Fatasi Lambari PS. He also stated that as per his knowledge, the following said motor vehicles were kept there: one Bolero vehicle, one Scorpio, one oil tanker, one bus, and many other vehicles. On receiving information, the OC immediately went and along with him at the same field and found the seized vehicles and missing from there. After that, the matter was inquired to Uttam, who is the manager of the Om Shanti Vivah Bhavan, located beside the said field, who then stated that about 1 month before, Paresh Dole, the chowkidar of the said field, came along with 2 traffic personnel and sold the vehicle to some scrap dealer, and the scrap dealer cut all the vehicle into pieces and took away the cut vehicles by loading on a truck. He also stated that some traffic police personnel came along with him, so he did not find any reason to doubt. But after that incident, the chowkidar Paresh Dole never came for his duty and has fled away. After knowing the fact, the OC immediately informed the matter to DCP West and other senior officers, and on their instructions make it a GD entry white Fatasi Lambari PS GD number so-and-so, and asked me to inquire into the matter. During inquiry, the mobile phone number, phone location of chowkidar Paresh Dole was spotted, and so the OC SI Sanjay Mudoi, PS staff, and myself went to Japurigop, Jonaki Pot, and apprehended Paresh Dole from his residence for interrogation. During interrogation, he has given the list of the seized vehicle sold from the said field: 1 oil tanker, 1 truck, 1 Scorpio, 1 Bolero, 1 Maruti van, and 2 number of auto rickshaws, 1 Yodha, 1 recovery van, 1 Bolero pickup, and many other vehicles. He also revealed the names of others involved in the case: Ratul Kakoti of Birubari, and Rakesh Gwala, that is the petitioner, and Kulen Gogoi. He also informed items were purchased by Rakesh Gwala and Ratul Kakoti. Accordingly, Rakesh Gwala was apprehended from his residence at KK Road, house number 12, Fatasi Lambari. During interrogation, he confessed that he has received the seized vehicle from Paresh Dole without authorization and cut them into pieces for moving them to scrap shop. In course of investigation, it was learned that Paresh Dole was not the chowkidar of the field, but he was serving as an upper division assistant of Tribal Development Authority. Further, during preliminary checking of the available PS record, it was found that aforementioned Scorpio vehicle having registration number so-and-so was seized, a white Fatasi Lambari PSGD dated so-and-so and dated so-and-so. It is also pertinent to mention here that vehicles were seized in different cases of Fatasi Lambari PS long years ago, and so the case reference and MR number of all the said vehicles will be mentioned in due course of interrogation after thorough checking available of records. It is to be mentioned that accused Paresh Dole was the in charge of the field where the seized vehicles were kept under the safe custody, as there was no available place at the Fatasi Lambari PS. Further, during inquiry, it came to light that receiver of the stolen property, Rakesh Gwala, and Ratul Kakoti are habitual receiver of stolen property, and after receiving the stolen property, they have disposed of the stolen items by cutting them into pieces. In the light of the above inquiry, it is crystal clear that accused persons Paresh Dole along with Mondal, Kulen Gogoi have stolen many seized vehicles, etc., etc., etc. My lord, this is the allegation. It's a fact, my lord. I have purchased it. Now, please come to my petition in 3 paragraphs, my lord.
Paragraph?
Paragraph 4(3). Page 6. This is the actual state of affair, my lord. That the accused petitioner states that on 1st week of July, some persons had approached the accused petitioner and had stated that there are some old vehicles which are lying in the field of the Tribal Development Authority, Fatasi Lambari. The caretaker of the said vehicle, co-accused Paresh Dole, wants to sell the same. Accordingly, accused petitioner and co-accused Ratul Kakoti met Paresh Dole and saw the same were not vehicles and were mere remnants of vehicle. Because, my lord, it was seized in way back in 2003. So one can very well visualize the condition. The co-accused Paresh Dole stated the vehicles which are lying on the field were seized in connection with some cases by Fatasi Lambari police station a long time ago. But as there is no space in the premises of the police station, hence the same are kept in the field in his custody. The co-accused Paresh Dole further stated that Mir Hussain, in charge of traffic branch of Fatasi Lambari police station, had specifically stated to him that there is an order passed by the police department to dispose of the old vehicle which are kept in the field. The co-accused Paresh Dole had also shown a copy of the order in his mobile phone. Hence, on a bona fide belief, the accused petitioner showed his intent to purchase the scrap of the vehicle. The price was fixed at rupees 3,90,000 after negotiation. The accused paid 3 lakhs in cash, an amount of 90,000 through internet banking to co-accused Paresh Dole. The accused petitioner states that cutting, loading and transportation of the scrap of the vehicle started on 8/7/24 in the field of the Tribal Development Authority, Fatasil, and continued till 13/7/24. The entire exercise was carried out for a total period of 6 days is in broad daylight. However, none of the police officials had either questioned the accused petitioner, his main agent laborer, or had tried to stop the work of cutting, loading and transportation. It is needless to state herein that the field of the Tribal Development Authority, Fatasil, is an open space and is clearly visible to everyone. Moreover, the field of the Tribal Development, Fatasil, is located at a very close distance from the Fatasi Lambari police station. In spite of that, Fatasi Lambari police had filed an information. Now, my lord, what had happened? Actually, my lord, this traffic inspector, he is the culprit. I bona fide, my lord, believe because an order was shown to me in this mobile phone that there is an order of the government. So I purchased it, my lord. Now, end of the day, I will face the trial, my lord. Now, goods have been seized. I am in custody for almost 20 days, my lord. Now, why my custodial interrogation is necessary?
When were you arrested?
I was arrested on, my lord, 23/8/24. My humble submission is, my lord, it was my misfortune. And but this is the first time, my lord, I am encountering a criminal. Well, I have a spare parts shop, my lord, where I also deal in second-hand spare parts. My lord, I am a businessman. If I can invest my money and make some money, that's not wrong, my lord. So my humble submission is, my lord, why any further custodial interrogation? In fact, my lord, after following 3 days of remand, I was given to judicial custody. Since then, I am in jail, my lord. So therefore, my humble submission is, I will cooperate, my lord. And I belong to a good family, my lord. I am a respectable person. So I'll humbly pray, my lord. I think he should be enlarged on bail, my lord. I'll abide by any condition which your lordships would like to impose. I'll face the trial, my lord. My further detention is not going to help, the investigation in any manner.
Yes, Mr. Parashi.
Here in this case, lordship, one report was called for from the IO lordship, OC concern lordship.
What report?
On that, on earlier occasion, lordship.
What was the last order?
That is lordship.
My lord, last order is of 6/9. No?
Why police personnel did not know about that scrap of the material vehicles, lordship? That is the reply, lordship. And apart from that, lordship, in CD lordship, sufficient material has been collected against him, lordship. And he himself has stated, lordship, he knew that those cars are of police vehicles, police seized vehicles, lordship. And he scrapped all those vehicles, lordship, asking that person who is the official person of that Sangha, lordship. But he could, if there is no any ill intention, then he could have asked the OC concern or the police personnel, lordship. And as per the when there is a statement of the Forest Dole, he never said, Lordship, that he has,
No,
that,
but
I don't,
police was not aware
Lordship.
in day, broad
Because
day,
this was done, Lordship.
For 6 days.
This was within 6 days, Lordship.
6 days since,
Lordship.
since
Only
7.
Because
From police
Yeah.
station, one can view, my lord, everything.
that report is regarding that, and that is the report, Lordship. That report has
Since
called for, Lordship.
8th to 13th. It continued for 5 days
5 days, Lordship.
and you have lodged FIR after 10 days.
Lordship.
So police was not aware that
As
This
per
is
their
vehicles
statement also,
are-
they did not visit all the time because it is all the from last 20 years, 30, 25 years, vehicles are kept here.
so no
And
police.
yes, Lordship.
Now, do you need his custodial detention?
Lordship, because there are 2 persons are yet to be arrested, and there are some video photo after seizing his mobile number, some video footage he has received, Lordship, that regarding some
But-
monetary transaction with that Forest Dole and some other.
But he is admitting, he has admitted that he's not denying. He has admitted that.
But Lordship, illegally cutting those Lordship, those scrap material, those vehicle, Lordship, he has, because he is running a scrap shop, Lordship. There are some rules, Lordship. He himself has stated, Lordship, in his 161 statement, Lordship, that he knew that for that some NOC from the owner is required. The original certificate RC is required. So for processing that scraping the material, Lordship. But he did not call for that, Lordship. He did not notice all this only on the statement of a person who, of that tribal Sangha. He has done all
But
these
he
things.
said
Lordship.
that he was accompanied by some traffic police officer.
Lordship, this is their statement, and the traffic police has
Whether
also been
traffic
interrogated.
police has
Yes.
been made accused in this
Lordship,
case.
he has been interrogated, Lordship.
Whether he has been made accused or not.
Not, Lordship. That is not. And even if, on the as the Forest Dole, the main accused person, he has not stated, Lordship, that he has simply in his 161 stated, Lordship, he has stated, Lordship, he has a deal with the IO, Lordship, a traffic instance, Lordship, but he has not stated that there is some
Who is the IO?
not IO, Lordship, instance, Lordship, traffic instance,
Traffic in charge.
traffic instance, Lordship.
Now, what is this report?
This is regarding why police did not come to know for a long time, Lordship. Yeah, regarding that.
If police is not aware about its own belongings. Now we are concerned whether custodial detention is necessary or not.
Because, Lordship, now 2 persons are yet to be recovered, Lordship. Oh, arrested, Lordship.
Paresh is arrested. Paresh Dole is
Forest arrested another 2 person, Lordship. Here, Lordship.
I think all have been arrested, my lord. There are 4 persons all.
Madan Mandal and Pulon Gogoi.
how they are related.
They were, as per the statement, they are also involved in this entire. Forest Dole also stated, Lordship, that first Forest Dole approached these 2 persons, then these 2 persons bring that person, then they have a meeting, Lordship.
Now this cut scrap has been recovered.
Lordship, those articles has been recovered. Scrap. Scrap materials he has already sold it out, Lordship. But only the machine and the cutter has been recovered from his godown, Lordship. One person, he is a scrap dealer, Lordship. He could not go and scrap any vehicle. Lordship. Today I will stop a car there, and someone will say, "This is my car. You go and scrap it." And he only because I do not inquire about that vehicle, he cannot go for scraping and all articles, Lordship. He should have some. There should be some procedure, Lordship.
No, we are not concerned about that. We are concerned whether his detention
As
is.
per IO report, his further custodial interrogation is required, Lordship.
What?
He is IO not also, I may place it, Lordship. You can do it. I have not, Lordship.
Whether his statement has been recorded.
Recorded.
He is in judicial custody
His statement is-
because he is admitting they have implicated Mirjan Hussain. Who is Mirjan Hussain?
That is the IC, Lordship.
That is the police officer, my lord.
IC traffic, Lordship.
That's what's the design.
Heard Mr. K. N. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. T. Devi, learned counsel for the petitioner. Also heard Mr.
PS law.
P.S. Lawkor, learned additional public prosecutor. This application under section 483 of the BNSS, 2023 has been filed by the petitioner, namely Rakesh Gwala, who has been detained behind the bars since 23/8/2024 in connection with Ambari PS case number 226/2024 under section 61 within bracket 2 within bracket A small a /306/317 within bracket 4/317 within bracket 5/3 within bracket 6 of the BNS 2023. The gist of accusation in this case is that on 25 and 23/8/2024, one Jalilur Rahman, ASI of police of Fatasil Ambari PS police station had lodged an FIR before the officer in charge of Fatasil Ambari police station, inter alia, alleging that some vehicles which were seized in connection with different cases by Ambari Fatasil police station and were kept in which field? In
Tribal
in the field of Tribal Development
Development Authority.
located about 100 meters away from the police stations were found missing. It is also stated in the FIR that one Paresh Doloy, who is the chowkidar of the said field, came to the said field along with 2 traffic personnel and sold the vehicle to some scrap dealers. Stop. It is also stated in the FIR on getting the information, the said Paresh Dole was apprehended, and during interrogation, he gave a list of seized vehicle as mentioned in the FIR and has stated that he had sold these said vehicles, which were old vehicle, to one Ratul Kakoti and Rakesh Gwala, within bracket the present petitioner. Stop. Later on, stop. It is also stated in the FIR that later on it came to the light that said Paresh Gwala is not the chowkidar of the field, but was serving as upper division assistant of the Tribal Development Authority. Stop. Learned senior counsel for the petitioner has submitted that the fact that the petitioner had purchased all vehicles or some,
Certified, yes,
All
whatever,
the
certified number
scrap-
of vehicles.
This scrap which was generated, my lord.
the said seized vehicles, which were old vehicles, as he was informed by the co-accused Paresh Doloi that the said vehicles, that a decision has been taken by the authority by the police department to dispose of the old vehicles which are kept in the field. He also submits that he was also informed by the co-accused Paresh Doloi that the in charge of traffic branch of Fatasil Ambari police station, namely Mir Hussain, had specifically asked him about the order passed by the police department. It is also submitted by learned senior counsel by the petitioner that an order to that effect was also shown to him by the said Paresh Doloi. It is further submitted by learned senior counsel that considering that believing the statement of Paresh Doloi and on a bona fide belief, the petitioner purchased those vehicles at a fixed price of rupees 3,90,000, and out of which rupees 3 lakhs was paid in cash and remaining 90,000 was paid through net banking in Paresh Doloi. Learned senior counsel for the petitioner has also submitted that the belief of the petitioner never disbelieved the statement made by the said Paresh Doloi, as the transportation of the scrap vehicles was carried out in the daylight for 5 days from
6 days, my lord.
for 6 days from 8/7/2024 till 13/7/2024. And though the field is only the field where the vehicles were kept is situated only at a distance of 100 meters, none of the police officials from the Fatasil Ambari police station ever questioned either the petitioner or his men, agents or laborers regarding the work of cutting, loading, and transportation of the seized vehicle. Learned Senior counsel for the petitioner has submitted that the petitioner has not denied that he has not purchased the vehicle. However, and he is ready to explain the circumstances and cooperate in the trial. And therefore, his further cooperate in the trial, cooperate in the investigation, cooperate with the investigating officer in the investigation. However, he has been detained behind the bars since last, how many days?
20 days, today.
Since last 20 days. It is submitted that his further custodial detention may not be necessary. Hence, he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Ambari PS case number 26/2024. He has also produced a report dated 11/9/2024 by the officer in charge of Ambari Police Station in compliance to the directions made by this court by order dated 6/9/2024. Stop. By the said order, a query was posed as to how police could not know about the as to why the case diary does not reflect as to how in the broad daylight, the large numbers of seized vehicles which were seized by police and kept in an open field were cut, loaded and transported without being noticed by police personnel. Stop. In his report, on perusal of the report, it appears that the officer in charge of Ambari Police Station has stated that as the said vehicles were seized about 20 to 25 years ago, and same were kept in the field of Assam Tribal Development Corporation Limited. The same was looked after by accused Paresh Dole, and therefore police never doubted him and have faith on him It is also stated by the OC Ambari Police Station, Ambari Fatasil Police Station, and that the field is not visible visible from the police station. Though stop the report furnished by the officer in charge of Ambari satisfactory, and it does not explain the reasons properly as to why the loading, cutting and transportation of seized vehicle could not be noticed by the police personnel of the police station, which was located about 100 meters away from the place where the seized vehicle were parked, however, it is apparent from the report that even police relied upon the co-accused Paresh Dole, from who had given assurance to the present petitioner that he was informed by the in charge of traffic, namely Mir Jahan Hussain, regarding disposal, regarding an order of the government regarding disposal of the seized vehicle. The petitioner has not denied anything in his bail application. Rather, he has admitted that he has purchased the seized vehicles. He has only explained the circumstances under which he purchased the seized vehicle. Stop. Learned additional public prosecutor has submitted that two of the co-accused, namely, two of the co-accused are yet to be apprehended. However, after going through the two of the co-accused, namely Madan Mandal and Kulen Gogoi, three of the co-accused, namely Madan Mandal, Kulen Gogoi and Rameshwar Singh are yet to be apprehended. However, this court does not find any reason as to how it will help, how the continued detention of the present petitioner, who is ready to cooperate in the investigation, would help apprehension of those co-accused who are yet to be apprehended. The statement of the present petitioner under section 180 of BNSS has been recorded. It also appears that the investigation against involvement of SI Mir Jahan Hussain is going on. Stop. This court is of considered opinion on the basis of the materials available on record, as well as facts discussed herein above. This court is considered opinion that if the petitioner cooperates with the investigating officer in the investigation, his continued detention may not be necessary for fair completion of the investigation of Ambari Fatasil PS case number 226/2024. Stop. In view of above, the petitioner Rakesh Wala is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions: that the petitioner shall appear before the investigating officer every week for next 4 weeks or till the investigation is completed, whichever is earlier. The petitioner shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the investigating officer. With above observation, this bail application is disposed of. Send back the case diary.
Item 16 of application.
May I please, Lordship, last occasion, Lordship, scan copy was called for, Lordship, but as per office note dated, Lordship, 10/9/2024. Lordship,
It is not arrived.
not arrived, Lordship.
We'll await
Lordship,
next week.
next week, any date, Lordship.
Heard Mr.
Ayu Chaudhary.
I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. The office note dated
10/9/2024.
10/9/2024 shows that the scan copy of the trial court record along with the scan copy of the case diary has not been received. Stop. Issue reminder for the same. Let this case be listed again on when 19/9/2024.
Obliged.
May I please, Your Lordship? This search-seated matter, Lordship, and trial is going on. FIR is on page 14, Lordship.
How many witnesses are there?
19 witnesses are there, and 7 witness deposition has already been taken, Lordship.
Where is the FIR?
FIR is on page 14, Lordship.
What is the allegation?
Allegation is that
How many accused are there?
2 accused, husband and wife, Lordship.
Whom you killed?
Both, Lordship.
What is the allegation?
Allegation is the petitioner number 2 strike the Lordship, strike with one wooden stick, Lordship, the victim person, and he died after 5 days while he was under treatment, Lordship. বিনীত নিবেদন এই যে যোৱা ইংৰাজী 24/1/2024 তাৰিখে ৰাতিপুৱা 9 বজাত মোৰ ভাইটি সদানন্দ বৰাৰ ওৰফে পিতো মোহন বৰা পিতা
Petitioner number 2 means wife.
Petitioner number 2 is the husband and petitioner number 1 is the Ritusmani Bora. He is the wife of the accused number 1. Lordship.
Since when you are behind the bars?
I am behind the bar since 4th of February 2024. Lordship. Scan copy not received, madam. Scan copy not received, but I have
scan copy was called for.
Called
It is,
for.
my lord.
But deposition, the statement of deposition lordship available.
The scan copy call. My lord.
Deposition of 7 witnesses. This is a certificate copy lordship.
What is the statement? They have implicated you?
Only the son of the victim lordship, he told that he's seen that this accused number 2.
You
the petitioner.
assaulted. And how many witnesses are there now?
Remaining 12 witnesses there. Already prime witness is already taken lordship. Evidence of prime witness.
Who are remaining? Or we will call for the scan copy.
Lordship, this lordship.
If the main witnesses have been examined, Mr. Burwa, then they may be released.
No, my lord, my question is that, my lord, out of 19 witnesses, 7 witnesses have been examined. My lord,
Oh.
whether, my lord, these 7 witnesses are, my lord, material witnesses or not, that we have
Yes.
to go to from the scan copy, my lord.
Yes, that is the
That
query.
is, my lord,
It is a-
call for this, already it is called for, my lord. So
Okay.
reminder may be useful.
Okay. Heard Mr. Milan
Lordship.
Kumar.
May please lordship. The children of the petitioner lordship, school going children, minor children, due to the confinement of their parents lordship.
We'll release the wife now.
Yes, lordship. My
Sir,
humble prayers.
Let us, my lord, one more chance may be given because my lord, this can be already called for, my lord. That is not received, my lord. So next day, my lord, we'll
Lordship,
the scan copy,
and
my lord.
his petitioner number one's allegation is that only I have handed over one bamboo sticks to my husband, lordship. That is the allegation only.
Not bamboo stick, my lord. It's a wooden batam,
Wooden
my
stick,
lord.
wooden stick, lordship. That is already mentioned here, lordship. At least there's also considering the education purpose of their children, lordship, and they are taking their shelter in their.
They are already behind the bar, my lord, since the
uncle-
date of
uncle house,
incident, my
lordship.
lord.
And
If
that
they
is-
remain,
that
my
is-
lord,
that
if they
is
remain present for 1 more week, my lord, nothing will hamper, my lord.
A distance from their maternal uncle lordship. So
Okay. Let us give in the next week. If in the next week it does not arrive, you may press.
Yes, my lord.
It is only petitioner number 1, lordship.
4 days, wait for 4 more days.
Lordship.
Heard Mr. M.K. Neo, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor. On perusal of the office note dated 10/9/2024, it appears that the scan copy has been received. Only charge sheet has been received. Scan copy of charge sheet was called for only.
My lord, the entire scan copy of the mother LCR may be called for, my lord. Along with the mother up to date status report. Just Sarshil, my lord, here the petitioner has already annexed, my lord, along with the bail application.
Then why it was called for?
And the victim was died while he was under treatment after 6 days or 5 days later, lordship, while he was under treatment at Diggur Medical College and Hospital, lordship. An FIR was filed after 22 days, lordship, from the date of occurrence.
PM report to specific lordship, death was due to coma as a result of head injury, my lord.
I am not denying that, lordship, but my nexus is not to kill her, lordship, kill the victim person. Accidentally, because the victim person provoked the petitioners, both the petitioner for various days, lordship, due to the some
Okay,
personal.
heard. Can. Scan copy of the charge sheet, which was called for, has arrived. However, learned additional public prosecutor has submitted that the scanned copy of the entire case, Sessions Court record, Sessions case number 84/84 within N bracket NL/2024 would be required. Hence, call for the scanned copy of the record of sessions case number 84 within bracket NL/2024. Why if I am releasing?
I am only, my lord, praying, my lord, since it has not come, my lord.
No,
After
no,
perusing, my lord.
no, but that was not called for.
Well, it's a certificate case, my lord, we have to peruse the scheme, my lord.
Certified lordship,
Because we
I am
cannot rely on the, my lord, bail application filed by the petitioner, my lord.
certificate page
It is, I am
17,
praying, my
lordship.
lord, only, my lord, next week, my lord, any date, my lord.
Page
next week.
17 lordship, certificate lordship. I have annexed it.
Let this scan copy be called for. Be called for. Let this case be listed again on 19th,
My lord,
19th September.
my lord.
Can it be on 16 lordship?
Okay, 16.
16 is, my lord, 16 is Monday, my lord, the 17th.
17.
Obligation.
That's me. I'm sorry, Lordship, I was seeing another case, Lordship.
Yes.
Okay, here this case, Lordship, the petitioner is in custody as on today, Lordship, 49 days, Lordship. And the FIR will file case number 10, Lordship. My name is not in the FIR, Lordship, but the other two FIR name accused, one Sahabul Islam and another is Mofidul Islam, and they were arrested and subsequently on the basis of the statement of the co-accused, Lordship, and I have been arrested, Lordship. And Lordship, one thing, Lordship, and yesterday the item number 15 and already a co-accused already grant bail, and as per the I have gone the order of the Honorable Court, and he has been implicated in one more cases and also reflected in the order, Lordship, and yesterday passed by your Lordship. I have provided. So, Lordship, and my name is not in the FIR, Lordship. Only statement of the
What is the allegation?
allegation, Lordship, some fake currency and gold, Lordship. But Mofidul is the pattern criminal, Lordship. The FIR itself is very clear, and the my lord order passed yesterday, Lordship, and that is reflect the one more case against pending against him, Lordship. So, my lord, I have.
What is your name?
My name is Zomir Ali, Lordship.
Same FIR.
Same FIR, same parole.
The allegation is against Sahabul.
Shahabul and one Mofidul, Lordship. Their name in the FIR, Lordship.
Yes, Mr.
Yes, my lord, yes, his name is not there in the FIR, but police, my lord, on the basis of the source information, my lord, police arrested one, my lord, Sahabul Islam, my lord, initially, and
Sahabul possession.
Yes, recovered, but from the present petitioner also, my lord, seizure list is available in the case diary, my lord, from Zamir Ali, my lord. One suspected to be fake gold piece, golden color, one both shape, weight approximately 1 kg, 676.676 gram.
Anything else?
Because this is a huge gang of network. They are operating.
No, but possessing fake gold is not an offense.
Because why they possess those fake golds? There are many instances. Your lordship may kindly produce the case there for cheating, various persons, your lordship from social media they collected various data.
The offense is possessing counterfeit note.
Exact, Lordship. But the case, Lordship, the individual person.
What is 61(2)?
61(2) is
BNS.
Criminal conspiracy,
Then 3184.
Yes.
Mr. Hawk, you have to be ready.
Sorry, Lordship.
Otherwise, we'll take it up on some other day. You come prepared with the.
I'm sorry, Lordship.
We'll take it up after lunch. After lunch.
Lordship.
Till then, you memorize these sections.
Lordship.
Next. After lunch.
At two, Lordship.
At two.
Lordship. Obliged.
Your Lordship, I'm in deep trouble, Lordship. I had item number 1, Lordship. What happened, Lordship? Item number 29 also similar, Lordship. He is the prime accused, Lordship. Lordship is granted bail, Lordship, in first half, Lordship. Item 29, Lordship.
Okay.
He is the prime accused from whose possession the article says seized, Lordship. I was just introducer, Lordship. My item was 1, Lordship. I was not aware of the fact, Lordship. Just now I have
Item 1, we have passed orders.
Lord, if it's not signed, Lordship, kindly, Lordship, Lordship, I'm in deep trouble. Lordship. I was not aware of the fact that 29.
We have called for the case diary.
So if order is not signed, Lordship, Lordship will take up. Lordship, case diary is also here, Lordship. 1 has been granted bail.
When the date is fixed.
So 19, Lordship. He is
Will-
the prime accused, Lordship, item 29.
Will not take it up today.
But as the last item, Lordship, before court rise, Lordship. Lordship, kindly, Lordship.
Because last item we are unable to reach today.
Before court rise, Lordship, it will be similar order, Lordship. That person has been already granted bail, Lordship, the prime accused, Lordship. Kindly, Lordship, I mean, deep trouble, Lordship, otherwise, Lordship. Lordship, kindly, Lordship.
Item number?
1, Lordship.
Yes, Mr.
1 and 29.
I have not gone through the case diary. For me also, it is difficult to go. in the case.
Not today. We are postponing it on Friday.
Friday, Lordship, I'll be out. Lordship. I'll not be.
Monday.
And Lordship, it will be similar.
When
order.
can we take Mr. Botakar?
Sir, to your Lordship, may I fix any convenience as per your Lordship convenience?
Let us take it up tomorrow. You go through the case diary. One who took the dictation. You. Demand one, release this matter tomorrow on request of Mr. S. Munir. This matter on 12/9. Tomorrow will.
Much of the highly obliged, Lord. Highly obliged, Lord.
Please, your Lord. I have taken concept of the other side, my lord, regarding item 13, my lord. It may come up after vacation, my lord.
Item number 13.
13.
Heard Mr.
S. Alim for the respondent.
S. Alim, learned counsel for the respondent who prays for adjournment. He submits that he has obtained the consent of learned counsel for the petitioner side regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
I am highly obliged.
Yeah, please, your Lordship. Lordship, I beg your indulgence, your Lordship, for troubling your Lordship. Item number 42, Lordship. Lordship, because of some personal difficulty, I have to leave you, Lordship. Item number 42, other day, your Lordship has come up, your Lordship. Lordship, what happens is that.
No, what do you want now?
Lordship, there are 2 CD, Lordship, against which we have filed bail petition, your Lordship, that is already available, your Lordship. So far, the other case diary, that is 173 is concerned, your Lordship. Maybe Lordship not.
No, item number 42, what you are mentioning?
Item number 42, your Lordship, may be taken, your Lordship, some other day, your Lordship.
Some other day.
Some other day on Thursday, your Lordship.
Friday. Heard Mr. A. Devan, on request of Mr. A. Devan, learned counsel for the petitioner. Let this matter be listed on 13/9/2020.
13, that CD has to come. Okay, my lord.
CD is there.
No, that CD is not available, my lord. 13 is not possible. Maybe on Monday.
Okay. Then on 16/9. 16/9.
16.
Item 13, there is an interim order.
In item number 13, interim order shall continue till next day.
Obliged.
Item 55 for availability.
Spoken to. Kuntu. I have lost my notings in this case. So you have to give one or 2 page written submission.
My lord.
When can you give?
1 week, my lord.
Okay. Then give it on. No, you take 2 weeks. Give it on 24th. 24th. Heard learned counsel, heard Mr. You the SOK. You are for?
I'm for respondent. I am appearing on behalf of Dilip Saikia.
Heard Mr. SOK, learned counsel for the petitioner. Also heard Mr.
MD Imran.
M.
MD Imran.
MD Imran appearing for the respondent side. The counsel for the parties are requested to submit a brief written gist of their respective argument on the next date. Let this case be listed again on 24th of September 2020.
That's okay.
Item 24. Lordship. Well, this case, Lordship, so far section is concerned, Lordship, and all the sections are not against me, Lordship, but because, Lordship, the 61(2), Lordship, with the criminal conspiracy.
61(2) is?
Criminal conspiracy, Lordship.
Okay.
And Lordship, 318, Lordship, the
What is-
sitting, Lordship, but I have not communicated with any other person in connection with the.
Sitting. And other sections are?
And Lordship, and the 179, Lordship, that is the counterfeit coins, Lordship, that is not recovered from my possession.
Okay, 180.
180 is, Lordship, for the possession of counterfeit currency, Lordship.
1112.
1112 is organized crime, Lordship. But I am, as per the statement of the.
Yes, my lord, these are, my lord, all these initially, my lord, one Sahabul Islam arrested on the basis of source
But
information.
from his possession, only a boat has been recovered.
Yes, my lord, and my lord, FSL report also received regarding that boat, and that boat is a, my lord, a major component of copper and zinc, so my lord, fake gold.
No, but possessing
Yes, sitting is also there by using these, my lord, fake golds. They cheated.
whom he has cheated.
My lord, regarding that, my lord, because not only, my lord, in this particular case, and there are many.
But we are concerned with this case. only.
Yes, my lord. In this, my lord, because there are, my lord, lots of cases of sitting by using these fake golds as genuine, my lord.
But for other cases, can he be detained
Yes,
for
my lord,
this?
that is true, my lord. Regarding
Okay,
that.
heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 483 of the BNSS, 2023 has been filed by the petitioner, namely Muhammad Jamir Ali, who has been detained behind the bars since 24/7/2024 within bracket for last 49 days in connection with North Lakhimpur PS case number 195/2024 under section 61(2), 61 within bracket 2/318 within bracket 4/179/180/1112 of BNS. The gist of accusation, quote from this remark, quote para 3 from this order, flagged order. Quote para 3, quote para 4. Learned counsel for the petitioner has submitted that the petitioner has been arrested only on the basis of the statement of the co-accused. However, no incriminating substance was found from his possession. Learned counsel for the petitioner has also submitted that the petitioner has been detained behind the bars for last 49 days, and considering the period of detention, he may be allowed to go on bail. He also submits that the petitioner is ready to cooperate with the investigating officer in investigation. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that there are incriminating materials against him in the case diary. He has also produced the case diary of North Lakhimpur PS case number 195/2024. Learned additional public prosecutor has also submitted that a fake A boat. What was found?
Both, my lord, both separate, my lord. One boat shape golden colored metal, my lord.
A boat shaped golden color metal
Weight is 1.68 kg.
weighing about 1.6 kg was found from his possession.
And FSL report also received.
What FSL report says?
FSL report, my lord, states that alloy of major component copper and zinc. So this is not pure gold, my lord. Fake gold.
An additional public prosecutor submits that the seized article is found to be an alloy of copper and zinc. Learned counsel for the petitioner, learned additional public prosecutor has submitted that said article is used by the petitioner in duping the innocent public by
By delivering them as, my lord, pure gold.
duping the innocent public by showing the by making them to believe that the article is of pure gold. Stop. I have considered the submissions made by learned counsel for the both the sides and have perused the case diary of Lakhimpur PS case number 195/2024. It appears from apart from recovery of the fake golden article, which is found to be an alloy of copper and zinc, no other incriminating material has been found from his possession. The case diary shows that the incriminating materials, that is fake currency notes, were found from the possession of the co-accused, namely
Sahabul Islam.
Sahabul Islam only.
Mofidul Islam also.
Mofidul Islam also.
Sahabul Islam and
Mofidul Islam.
not Mofidul.
Sahabul Islam.
Only Sahabul Islam.
Sahabul Islam.
From possession of Mofidul, nothing was found.
Lordship.
Sahabul Islam only. Stop. Considering the above facts, this court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair completion of the investigation of Lakhimpur PS case number 195/2024. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Lakhimpur, with following conditions. Number 1 and number 2. This bail application is accordingly disposed of. Send back the case diary.
Deeply obliged. Obliged.
Net pleasure of it. Here, FIR Lordship will find in 719 of 2023.
32.
Lordship.
Yes.
That FIR Lordship will find page 10.
Page
10.
What is the offense?
Here, NDPS Act, Lordship, the commercial quantity.
Commercial quantity.
Commercial quantity. And here in the FIR, from FIR Lordship, you will find that here they received the information accordingly. Naka checking was done, And from Naka checking lordship that in PV 04 and 8281. From this track lordship, they Ravinder Singh and Jewel Hussain, they were granted bail by your lordship. Thereafter, lordship, those things were recovered. And now, if your lordship kindly turn to at page 11, lordship will see page 11, top portion that after completion of search, third paragraph lordship, before description of articles, the completion of search process at 11:50 p.m.
Yes.
of 15/10/2022. So on 15/10/2022, the vehicle was apprehended. They were interrogated, and thereafter this FIR was lodged on 16/10/2022, but it was sent to the concerned magistrate on 17/10/2022. After 2 days. So till that period, lordship, there was no implication against the present petitioner, lordship.
Who are you? What is your name?
My name is lordship Qazi Ghulam Mustafa.
Who are you?
I am not connected with them, lordship. They have just named me that my implication, your lordship, will find in the charge sheet at page 24.
Charge sheet. It is a charge sheeted case.
Charge sheeted case. So NBWA issued, therefore I am before your lordship.
No. You appear before the trial court because trial court.
NBWA is there because if I go appear there, that may not be recovered. And without proper service of someone, lordship, NBWA was issued. That I can place from the order sheet itself, lordship. That someone was not served.
We will put hold on the NBW for few days.
Yeah, my only prayer is that, lordship, that for 10 days or 15 days, I may be protected in the that I will appear before the trial court, lordship.
Yes, Mr. Burwa.
My lord, I have perused the scan copy, my lord. As part of my lord, arrested accused person statement, my lord, he is the owner of the truck, my lord. They have stated that, my lord, only my lord, he is also involved, my lord. But nothing has been seized from it, that is clear, my lord. But in the search sheet, my lord, there has been shown as an absconder, my lord. That is why trial court, my lord, directly issued, my lord, non-bailable warrant of arrest. It's a
Without issuing summons.
My lord.
Without issuing summons.
Without issuing summons, my lord, subject to correction, my lord. I have gone
Summons should have been issued.
Yes, my lord. As per the interim on Gusami, my lord.
Yes, that is the law.
Directly cannot do.
So let them appear before the trial court. We are not, we are giving them interim protection.
My lord.
The trial court will be at liberty to decide regarding their bail application.
Just one thing I'm clarifying, lordship, that in second case, lordship, on the first day NBWA was issued, WA. And in this case, lordship, summon was issued, but that was not served. It is reflected in the order dated 30/9/2023 that summon has not returned. And on the next day, immediately, NBWA was issued.
What is the date fixed next?
That I have to take instruction. I
You
can get the date. Lordship may give me 10 days time. Within 10 days, I will appear, Lord.
10 days, my lord. Seven days time, my lord. 7 days, my lord. They can appear, my lord.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner, also heard Mr. R.J. Burwa, learned additional public prosecutor. This application under section 438,
Lordship.
438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Qazi Ghulam Mustafa, who is apprehending his arrest in connection with special NDPS case number 151/2022, corresponding to Bajari Chera PS case number 185/2022, under section 20 within bracket small b within bracket small Roman 2 within bracket small capital C /29/25 /25/29 of the NDPS Act, 1985. Learned counsel for the petitioner has submitted that the trial court has issued warrant, non-bailable warrant of arrest against the petitioner without ascertaining due service of summons issued to him by the said court. Stop. Learned counsel for the petitioner has submitted that the petitioner is ready to face trial and therefore prays for allowing him to go on bail. Stop. On the other hand, learned additional public prosecutor has submitted that in this case, this is a case involving commercial quantity of contraband. Stop. However, he also submits that
There is a bar, my lord, under section 438, my lord.
Oh,
Regarding
he-
commercial quantity.
in
Because
granting bail, in granting bail.
Since it is searched
Okay.
case, my lord.
What was the last line? Commercial quantity of contraband is involved. And therefore section 438 is bar.
438 bar, my lord.
438 bar is not there. Our courts.
In case of my lord, commercial quantity, my lord.
No, otherwise bar is there. 30, section 37 NDPS Act bar is there.
Yes, cognizable and non-bailable, my lord.
But for NDPS cases, anticipatory bail is permissible. There is a judgment of this court.
And even in second case, Lordship, I have enclosed those orders also,
No,
court in advance orders.
no. No. What is the last name? Contraband. Hence, there is a statutory bar in granting anticipatory bail to the petitioner. Stop. I have perused the case record, and considered the submissions made by learned counsel for the petitioner. Whether it appears from record that without ascertaining due service of
Last order, your Lordship may receive.
it appears from record that which order?
7/12/2023. It was NBWA was issued. Prior to that, it is some 39/23. First, last summon was issued on 30/9/2023.
And when the NBW was issued?
NBWA was issued on 7/12/2023.
There is no date. After 28.
7/12/2023, that order is there, NBWA.
No, after 28/11/23, next date is 12/12/2023.
No, I'm saying about Lordship, 30/09/2023.
NDPS is 150.
NDPS case 151 of 2020.
Okay. But order sheets are not there. Seven 12.
7/12/2023.
That order is not there. Do you have that order?
Yes, certificate copy we have. 7/12.
This was for the first time NBW.
And the Lordship will find 39/2023, that was the last summon was. And in between only production were there, production of arrested accused persons.
Yeah, Lika. Case record. Scan copy of the case record. It appears from record that on 39/2023, learned the trial learned special session judge Karimganj had issued summons against the present petitioner, namely Qazi Ghulam Mustafa, and on 7/12/2023, the warrants, non-bailable warrant of arrest were issued against him. However, from the record, it does not appear that the learned session judge was satisfied. Learned session judge either perused the report of the service of summons or was satisfied that the summons were duly served on the petitioner before issuing non-bailable warrant of arrest against him. In view of above, this anticipatory bail application is disposed of with an observation, with a direction to the petitioner to appear before the trial court within 7 days from the date of this order.
Next date is on December 5, 2024.
December 5,
2024.
but you appear before that.
10 days, Lordship.
Within 10 days. Within 10 days from the date of this order. And after appearing before the learned sessions, appearing before the trial court, the petitioner may pray for bail, regular bail before the said court, if so advised. And on such, if such an application for bail is filed, the trial court to facilitate the appearance of the petitioner before the trial court, the operation of non-bailable warrant of arrest issued against the petitioner by the trial court shall remain suspended till next 10 days. For next 10 days. With above observation, this anticipatory bail application is disposed of.
May I pay for interim bail, Lordship, because I have unclosed some other coordinate bench order which was of 10
No,
days that
no.
day.
No interim, because
otherwise-
interim bail embargo is there.
No, 37 is there, but that
Then for
reasonable
bail, you
ground,
have to
Lordship.
jump that embargo.
Lordship, that reasonable ground, that for that, Lordship, I have already placed.
You are
the-
only, your,
co-accused statement. And that is not admissible in view of Lordship Tufan Singh's judgment. Lordship, that even that Tufan Singh
no,
judgment.
that plea you may take before the, now you are not arrested. We are giving you protection. That plea you can take before the trial court. That embargo is not applicable because of that judgment. The trial court is
That
well
observ-
with.
that observation may be there, Lordship, myself. myself.
You make submissions before the trial court. Because if Tufan Singh judgment would be applicable for trial court also. But let me not bind the trial court now. In next item,
In next item also, Lordship, on the first day, NBW was issued with warrant of arrest.
heard Mr. A. Ahmed. This is item number
Item number 33, Lord.
33. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed. Why this matter has come up before this bench?
Lordship, in the charge sheet, about both cases were mentioned in the first item. So earlier we prayed before this court that that may be segregated, but
No,
court
no.
said that it will be
This
taken up
case,
together.
this court is not taking up special cases. Then why this has come?
No, in first case, your Lordship has dealt with the other co-accused bail.
Okay, okay. This, what is the last name? Of the Code of Criminal Procedure, 1973 has been filed by the, he is also Qazi Ghulam Mustafa.
Here also. Lordship, in this case.
Same
Lordship,
person.
Same person.
By the petitioner Qazi Ghulam Mustafa, who is apprehending his arrest in connection with special NDPS case number 96/2022, corresponding to Bajari Chera PS case number 114/2022, under section 20 within brackets small b within bracket small Roman 2 within bracket capital C /25/29 of the NDPS Act, 1985. Learned counsel for the petitioner has submitted that the petitioner is apprehending his arrest in the above mentioned case as the learned as the trial court has issued non-bailable warrant of arrest against the petitioner without issuing summons to him. Stop. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the in the trial, and hence praise for allowing him to go on bail. Stop. On perusal of the, on the other hand, learned additional public prosecutor has submitted that has opposed the grant of bail to the opposed the grant of anticipatory bail to the petitioner on the ground that commercial quantity of contraband is involved in this case, and hence statutory embargo of section 37 is applicable to this case. Stop. On perusal of the case, perusal of the scanned copy of the record, it appears that when it was issued,
12/5/2023.
that after receipt of the charge sheet by the trial court, without issuing summons to the present petitioner, had issued non-bailable warrant of arrest at the first instance on
12/5/2023.
12/5/2023. Stop. The law in this regard has been settled that after receipt of the charge sheet, irrespective of the status of the accused shown in the charge sheet, the trial court should have issued summons to him at the first instance. Stop. Therefore, in view of above, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the Court of Learned Sessions Judge / Special Judge Karimganj in Special NDPS case number 96/2022 within a period of 10 days from the date of this order. Stop. On his appearance before the said court, the petitioner may file an application for regular bail, if so advised. Stop. If such an application is filed by the petitioner, same shall be considered by the trial court as per law. Stop. To facilitate the appearance of the petitioner before the trial court as directed herein above, the operation of non-bailable warrant of arrest issued against the petitioner by the trial court shall remain suspended till next shall remain suspended for next 10 days. With above observation, this anticipatory bail application is disposed of.
Item 45.
May I please, Your Lordship? Item number 35 and 36 is arising out of the same FIR, Your Lordship. The Lordship may kindly take up item 36 first. Your Lordship.
Why 36 first?
Lordship, then it will be helpful for this honorable court. Your Lordship.
Okay. 36, yes.
Petitioners are in interim, Your Lordship. Up to date, case diary was called for, Your Lordship.
Case diary is there.
Yes, my lord. Yes, sir.
Yes, what is the offense?
Offense is, Your Lordship, under section
You are on interim bail.
Lordship.
You have appeared before the
Lordship.
They have appeared, lordship, and on pressure of the case diary, my lord, it does not show them, my lord, the IO requires them for custodial interrogation.
Okay. Heard Mr. U.K. Deka, learned counsel for the petitioners. How many petitioners are there?
2, Your Lordship.
2.
Yeah, 36, Your Lordship.
In this,
35-1, 36-2, my lord.
in 35 you are taking up. But we are taking up 36 first.
36, 2 Your Lordship.
Learned counsel for the petitioners. Also at Mr. R.J. Borwa, learned additional public prosecutor who has produced the case diary of TOC PS case number 68/2024. Stop. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court by order dated 29/7/2024. And in pursuant to the directions of this court, both the petitioners, namely Debashish Buragohai and Ankur Setia, have appeared before the investigating officer and have cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of TOC PS case number 68/2024 and has submitted that the petitioners have appeared before the investigating officer and their statement have already been recorded under section 180 of the BNS. Stop. Considering the fact that these statement that the petitioners have complied with the directions of this court and have cooperated in the investigation, the interim bail granted to them by order dated 29/7/2024 is hereby made absolute with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is disposed of. Now 35, same.
35. There is one petitioner. Your Lordship.
35 also same order. Petitioner on নাম বেলেগ থাকিব. Same. You have taken 36 now. 35 is exactly same order except the name of petitioners and the date of the interim order. Date of interim order is same. It is also disposed of accordingly.
I'm deeply overlooked.
Yeah. The 37 case that is not received today, my lord.
Petitioner is on interim.
Heard Mr. H. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R. J. Borwal, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
23, my lord.
23/9/2024. The interim order shall continue till next day.
Oh, bless.
I don't know. Senior counsel, Mr. T. Z. Monto is appearing in this case, my lord. He is on legs, my lord. Can it be, my lord, after some time, my lord?
Okay.
I'm deeply obliged.
I think 41. Let's see. It is gonna appear before IO. That's fine.
It is there.
41 minute case that is not received.
Heard Mr. L. Gogoi, learned counsel for the petitioner. Also heard Mr. R. J. Borwal, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
27/9.
27/9. The interim order shall continue till next day.
Obliged. I think 43 and 44.
May I please, your lordship? This is an anticipatory bail application, lordship. These two matters arising out of same FIR. Lordship, he has filed the first one, the later one, so he may submit first.
The case that is not received, my lord.
They are on interim.
There is no interim.
When case,
There is no in both the cases to my.
when can you produce the case diary?
My lord, I say from call Gracia, my lord. This is on my lord.
Earlier occasion also, lordship, it is not.
17, my lord.
Earlier, he was produced, my lord. For the up to date CD, my lord, that time, my lord, return back.
Probably it was again.
Oh, yes.
We have to wait for the case diary.
And
Yes,
my lord,
Lord.
in this case, my lord, postmortem reproduced earlier postmortem.
Case is registered under another section.
Heard Mr. G. Samuel,
Yes, lordship.
learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who prays for, what is the case? Pocso?
No, lordship, no.
Okay. Who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
18th or 19th.
19th of September for case diary. Next item, same order. Name of the council will be changed
Case is registered under 396.
on 19th.
I think 45.
Obliged, ma'am.
May I please, your lordship? Lordship, matter may be taken up after some time. Lordship.
Okay,
We have received the case there.
okay.
Orders, item 46.
May I lordship?
What is this?
Lordship, notice was supposed to be served on respondent number 2, lordship, through the additional PP.
Notice has been served. Heard Miss D. Soikia, learned counsel for the,
I'm the amicus curiae, lordship.
or the appellant.
The appellant. I have received the paper book. It may be fixed for hearing,
Learned
lordship.
amicus curiae appearing for the appellant. Also heard Miss, this is a Pocso case.
Lordship.
Also heard Mr. P.
They give as honor, my lord. That is why, my lord, I have explained in para number 7, 8, and 9, my lord.
Heard Mr. T. J. Mohanto, learned senior counsel assisted by Ms. P. Sharma, learned counsel for the applicant. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 5 of the Limitation Act 1963. Limitation Act is 1963. You have mentioned it wrongly. 1963 for condonation of delay of
61.
89 days
89.
in preferring the connected criminal appeal, whereby the applicant has impugned the judgment and order dated 21/3/2023 passed by learned additional session judge cum special judge Pocso in special Pocso case number 4/2018.
18.
Here notice will have have gone to
Notice, sir, my lord. That is 6, my lord.
in 39 objection is there.
We have filed Vakalat and that same objection will be because relating to same FIR. If your lordship permits me to assist the PP, that will do because both the cases arising out of same.
Same, my lord. In one, probably he has filed affidavit, my lord. He has already
Because
filed.
relating to same society, same.
Okay. You want to object? You have any
I have already filed an objection, my lord, because he is not the complainant.
objection against his objection?
Objection, yes, my lord. I have objection against my lord. He is, my lord, Hindley application, my lord.
No, you have filed an interlocutory application.
No,
You have filed.
I by him, my lord. He claims to be the victim of this case, my lord. Accordingly, we have filed our objection in that case.
So whether that has to be decided first,
Yes.
Yes, my lord.
or if we allow that, we can go ahead with hearing of this case.
No, my lord. In the meantime, my lord, CD also come, my lord. Probably
Yes,
CD has come.
we can finally hear the matter. But that IA has to be disposed of, whether he can object or not.
My lord, he is not the complainant. And he is claimed to be a, my lord,
Victim.
one of the victim, my lord. But a victim, my lord, your lordship kindly see, this is the FIR lodged by the deputy commissioner. Your lordship kindly see district, the assistant director, food and civil supply. There are two down.
Oh, okay, let us allow him to assist the PP. Because PP will be objecting, you are objecting that. Let him assist.
My lord.
Then instead of wasting time on
My lord,
interlocutory
exactly,
application,
I understand, man.
we can hear the main.
Here in
You
this,
assist the PP.
my lord,
Then let us hear the item number 41st.
41st, my lord. I am representing 40, my lord. Same FIR, my lord. I am the president of that cooperative society. There is an allegation against the cooperative society by the deputy commissioner that there is a delay of, my lord, distributing, my lord, short delivery of the items, my lord, of the food and civil supply.
Short delivery of?
Short delivery, my lord, rice, my lord. That delivery delay, my lord, delay, that not short, my lord, delay. So for that, my lord, there is a show cause. We have replied the show cause and our license has been suspended.
License has been
suspended.
Okay.
License, my lord. Nowadays, my lord, cooperative society, my lord.
Agor case. Yes.
So thereafter, this, my lord, complaint was been lodged and accordingly case has been registered. Now, my lord, your lordship kindly see there are two allegations. One allegation regarding that, my lord, distribution of the PDF rice, my lord, to the school, to some particular school, my lord. And another, my lord, that is, your lordship kindly see FIR, my lord, there is a misappropriation of GPS fund.
At page?
Page, my lord, start from page 36, my lord. Page 36.
36 or 25?
No, 36 is the FIR, my lord.
Okay.
I'm going to the FIR, my lord, directly. Page
FIR.
36.
What is the allegation? You are the president.
I am the president of that cooperative society. And probably 39 one is the, my lord, item number 39, the secretary of the cooperative society.
Okay.
There is an allegation against both, my lord. Secretary and president, my lord. So
Okay.
there are
What is the allegation?
allegation, my lord, your lordship, my lord, straightway goes to my lord. I'll read the FIR, my lord. Or you can, my lord, directly go to the last portion of the FIR, my lord.
At page?
That is page 38, my lord.
Yes. Yes, please read.
May I read the page 38, my lord?
Yes, relevant portion.
Yes, but
which
when
you
I
are
was
in.
informed the GPS secretary, I did not complete the distribution of seized so-and-so MD rice to the school in spite of the being directed by the District Commissioner Morigaon. Then I inspector of the Morigaon GPSs again on 7/7/24 around 180.2 quintal of MDS PMGY rice go down another quantity of 760 or quintal of rice is in another go down. I immediately seized the quantity of the so-and-so rice and possession of Double Ali, Dolat Ali Khan, Vice President of the MS Nagarbaira GPS keep the same under the Zimma of the Pocso, the Secretary of the Women Society. So the Secretary and President of the MS Nagarbandha Gaon Panchayat are involved in the malpractice of a MDM rice and PMGY rice and misappropriated the GPS fund and the whole matter.
What is MDM?
My lord, midday meal.
Midday meal.
Midday meal. Then GPS's fund and the whole matter need to be part of the police investigation. So I request you to kindly understand the immediate police investigation to the matter and initiate action on as per law. This has the approval of the District Commissioner Morigaon and close the complaint so and so and so and so. So this is the my lord, and on pursuant to this my lord, your lordship kindly see that 315, 346, 318, 315, 346, 4 and 318, 4 and 320 BNSS has been registered, my lord. So, my lord, your lordship kindly see regarding my lord GPS already, my lord, that other I have in so course, my lord, details reply I have given, and for that, my lord, already I have been punished, my lord, our license has been cancelled. So far as GPS misuse fund is concerned, my lord, a cooperative such as a fund is, my lord, whether my lord is misappropriated or not, that can be decided only by the my lord. Only by the my lord audit report, my lord, annual audit report, and only annual audit report of the 2022-23 has already been done, and 23-24 has been, my lord, it will be completed by the next week, my lord. Your lordship kindly see how this misappropriation can be done, my lord. One of the members says, my lord, that it is misappropriation has been done. My lord, unless, my lord, the committee, my lord, there is a audit report, because everything is nowadays, everything go through my bank account, my lord. So my submission before your lordship, if police collected the audit report, everything will be cleared, my lord. So regarding so far is regarding fund. And so far is, my lord, the other parties concerned, my lord, already we have been punished. That is, license has been cancelled, my lord.
Okay.
And already 22-23, my lord, audit has already been submitted, my lord.
Regarding MDM, rice and
that, my lord, already I am explaining my our supposed reply, my lord. There is a complaint of, my lord, regarding late supply, my lord. Our supposed, my lord, your lordship will find.
at page?
Page 26, my lord, supposed reply. With due respect, page 26, my lord. An application for supposed reply. With due respect, I beg to your honor that I have received a supposed notice from you on 22/5/2024. That, sir, on the notice I have received a state that the complaint has been filed before the Honorable Assistant Director PDBFT CDM Morigaon Fund excess and illegal stock of excess of 41.32 quintal of PM rice in the GPS go down on 31/3/24
was illegally accumulated in the godown for illegal diversion into the black market, illegal monetary gain. That sir, and receipt of the complaint and after inquiry of the matter that the Honorable Assistant Director PDF CA Morigao, your Honor directed me to show cause as to why the PDS sub license issued in MS Nagarbera with GPSS Council and legal action should not be initiated. That sir, I am being the chairman and president of the Nagarbera, I have the responsibility to deliver the midday meal rice to the various pre-primary school and upper primary school in our area. That sir, as per the complaint allegation, I have rejected some of rice from the each beneficiary, but the dealer shop owner of our Nagarbera here go full amount of rice on behalf of each and every ration card beneficiary. No portion of the rice deducted by our Nagarbera GPSS. That sir, during the period of January 24 and April 24, I have received the MDM rice from the government of Assam, and accordingly I have given direction to the secretary of Nagarbera Government to deliver the said to MDM rice in the each of the school, and for this period the secretary GPS issued a case memo to MDM rice for the 5 numbers of school, that is so and so, that is Sosola LP school, amount of rice 12.266 quintal, to the Bhatu Khawati LP school, amount of MDM rice for so and so. Gorimari MEM amount of rice from 8.6 quintal. For Uttar Pasim Nagarbandha LP school, amount of MDM rice is 6.86 quintal, and 5 Lakharipan LP school amount MDM rice is 9.211 quintal, and total MDM rice 41.40 quintal. Sir, as a MDM rice has less amount in every school, as such the secretary Nagarbandha after issuing the its memo request to the headmaster of the school and to deliver the same MDS in a particular day, and for which it will be convenient for the secretary GPS to where the vehicle and the driver of the said MDM rice in a single day, and accordingly head of the headmaster of the school agreed for the same. That sir, I have never distributed blank new PS ration card, as I have not been authorized to select any distribution of a ration card. The secretary GPS has received the selected ration card from the code of the civil supply department, Morigao, and accordingly given and ration card each and every dealer shop, owner of the dealer shop, owner distribution, and ration card of the selected beneficiary. That sir, as I being the responsible citizen and as the chairman president of the Nagarbera GPS, I have never committed any crime in my past life, and I have no intention to sell MDF rice illegally. That sir, after seeing the MDF rice by the assistant director of food and civil supply and CA Morigao, I have many time request to allow me to deliver the said seized MDM rice in the particular school, as the said rice is belong to the poor and student who is given me to Maswari. It is therefore humbly prayed that your honor may please to note the cancel the license of MS Nagarbera Gapanchayat, also request not to take any legal action upon me, and also request to honor to please may kindly make a direction to the honorable assistant director of PN Morigao to allow.
When the license was cancelled?
My lord, that is annex, my lord. I have page 31, my lord. Annexer 5.
Now, what is your submission?
My
You are saying that license has been cancelled.
license has been cancelled.
Regarding that fund, unless audit is conducted.
Audit is conducted, my lord, regarding misappropriation fund cannot be, my lord. That cannot be, my lord.
Ascertained.
Ascertained, my lord. And in fact, my lord, for the year
And
2000.
regarding rice?
My lord, no, there is no shortfall of rice, my lord. Rice, my lord, what happened? I have explained, my lord. Particular day, suppose, my lord, for a only 40 kg of rice, my lord, we cannot send a car to deliver that, my lord. It will be, my lord, it will be not cost effective, my lord, because I have to bear that society has to bear the transportation charge. That's why, my lord, in 5 schools in one day, my lord, that headmaster said agree, my lord. So it is that only the complaint which was, I have annexed also complaint, my lord, that, my lord, they are delaying, my lord, distributing the midday meal. So that I have explained, my lord. Accordingly, my lord, they have not satisfied, and then my license has been cancelled. And that is even now it has been seized, and we don't do any, and it attached with another my lord society. But those who are the beneficiary of the fair price shop, my lord, there is no shortfall, my lord.
Have you approached the IO?
My lord, there is yes. There is an interim order passed by the Honorable Court. We produce the copy, my lord. They are not, my lord, taking any statement of me, my lord. I am ready to give statement, my lord. But when there is an interim protection given by the Honorable Court, my lord.
You appeared before the IO?
Yes, my lord. We submit our copy, my lord.
Okay.
And regarding, my lord, audit report of the next year, my lord, that is 23-24, my lord. That is, my lord, within 10 days, it will be completed, my lord. Now it is going on, my lord. Whole, my lord, game is played by the vice chairman, my lord. The vice chairman, my lord, he want to become a chairman, my lord, and he is projecting everything, my lord.
Okay.
So that is my submission.
My lord, this effort has been lost, my lord, after my lord preliminary investigation, my lord. My lord, what they have done, my lord. They are the, my lord, secretary and president of the, my lord, Nogabanda GPSS, my lord. My lord, they get the rice, my lord, under the, my lord, midday meal scheme and Pradhan Mantri Garib Kalyan Anna Yojana, my lord. They get the, my lord, rice and they distribute it to the school and the, my lord, the fair price of, my lord, so that it can be distributed to the money equally as per the direction of the government, my lord. Now, my lord, what they have done, my lord, in the inspection report, my lord, when the, my lord, authority comes, they have inspected the, my lord, Godown, my lord. Suppose, my lord, there should have been, my lord, 100 kg of rice, my lord. They have
Excess.
found more than 100 kg of rice, my lord. So that amount to show that, my lord, they have not properly distributed the rice equally to the, my lord, concerned, my lord, beneficiary, my lord. Secondly, my lord, the
For that,
statement of the,
they have given an explanation that they have kept the rice to be sent on a particular day because of transportation charges.
no, my lord, that will not help, my lord, in this case, because, my lord, after preliminary investigation, my lord, after inquiry, my lord, after inspection in the
It
Godown,
was
my
found
lord.
that they were at fault.
Yes, my lord, it was found excess, my lord. What has should have been remained, my lord. Then, my lord, fair price shop owner, his statement was also recorded, my lord. He has stated, my lord, when a 50 kg rice was allotted to 50 kg of bag is allotted to them, my lord, then half kg of rice is cut by the, my lord, the secretary and president, my lord. After, my lord, deducting half kg, my lord, the 50 kg bag. Suppose, my lord, he should get 100 kg of rice per day, my lord, or in a week, my lord. He has been given 99 kg of rice, my lord. This is the second allegation. Thirdly, my lord, the audit was done, my lord, and as per the audit report, my lord, they have misappropriated, my lord, huge amount of money, my lord. That is, my lord, I am submitting on the basis of the case there, my lord. But IOS, my lord.
Audit report not yet submitted, my lord. Audit report, it is
No, that is in the
next week.
that is in the case diary, my lord. It is done by a, my lord.
Submitted, my lord.
That is done by a, my lord. Internal auditor Habibur Rahman Siddiq, Hasimuddin Ahmed, and Mushtaq Ahmed. On the basis of this audit report, my lord, I was also given a note. So, my lord, I have strong objection, my lord, granting them, my lord, PRS bail. One person has not been granted PRS bail, my lord. One person, he is on protection, my lord. So I humbly submitted, my lord, his interim protection, maybe, my lord.
No, if they cooperate in investigation, then
No, my
why
lord.
you need their?
No, my lord,
Because
question is that, my lord.
Because they're like, I want to understand.
My lord, when the person will be, my lord, interrogated in police custody, and when he will be interrogated in some protection, my lord, there are differences in the investigation, my lord. Because, my lord, they have misappropriated, my lord. The case diary reveals, my lord, there are sufficient materials already collected by the IO, my lord. I am submitting, my lord. It is the investigating officer who requires, my lord, custodial interrogation, my lord. Because there are materials collected against them, my lord.
No, you have already collected materials.
Yes, that is why, my lord, when there is material, my lord, how can they be protected, my lord?
No.
Definitely, it is a discussion of this honorable court, my lord.
No, the question is why your detention should be for the purpose of investigation.
Well, for further investigation, my lord.
What investigation remains?
Further investigation yet to be done, my lord, because this money misappropriated, my lord, yet to be recovered, my lord. It's a huge amount of money, lord, around 50 lakh rupees, my lord. I'm submitting this from the case diary, my lord. And, my lord, the audit report reveals, my lord, they have not maintained any stock book, my lord. Stock book, my lord, and
Yes, you have any submission? Any counter?
My lord, regarding, my lord, audit report, my lord. there are 6 internal auditor, my lord. Out of 600 personnel, my lord, they are forced to, my lord, they have not signed it, my lord. This is the, I can produce it, my lord, we have affidavit, my lord. That in the final report, final audit report is yet to be submitted, my lord. By within 10 days, it will be available, my lord. Your lordship can ask to collect that, my lord. Who has submitted internal audit report, I do not know, my lord. But internal auditor, 5 of the internal auditor, my lord, they proceeded.
Out of 6 they have refused to sign in
They must have refused. My lord, your lordship kindly see this document, my lord. If required, I'll file by way of affidavit, my lord.
Also, notice is to be
What is this?
Yes, madam. My lord, these are the internal auditor, my lord. They have not their persons to the, my lord. They are asked to, my lord, internal audit, my lord. They say yes, in proper time I will do it, my lord. But they have not done it, my lord. So that's why, my lord, proper internal audit report is my lord. It is annual report has to be submitted, my lord. In person to the IO notice, my lord, they IO, my lord, forced the, my lord, to submit the internal report, my lord. Your lordship kindly see, my lord. There is reply by these 5 persons, my lord.
No, what was the inquiry report against you?
My lord.
What was the inquiry report of the inquiry? There was an inquiry held.
No, that is not been furnished to me, my lord. That is by the
basis of that, my lord.
That is not been furnished to me.
Where is that inquiry?
They have done internally by the Food and Civil Service Department. That is not been furnished to me, my lord.
No, how their remaining on bail will affect the investigation. If you can convince, I will not grant them bail.
No, my lord, since they were.
But otherwise, an inquiry has already been made. Sufficient materials have been collected. Their license has been cancelled. The godown has been seized and it has been given to some other Samabhai Samiti. Your license is cancelled. Now you don't have possession. They don't have access to that. Then why their detention is
So
necessary?
the recovery part is still there, my lord, misappropriation of money.
No, but that has to be ascertained whether they have, that is an allegation also only, that this much is, that has to be ascertained.
No, that has to be ascertained, my lord, but.
I will direct them to appear before the IO on regular basis till the period you want their interrogation. They will appear in the police station for interrogation. Mr. Azad, you want to say anything?
Yeah, in this case, lordship, they have lordship some transfers some money to their son's account also. And out of that 53 lakhs, and there are some other amount also which required to be lordship investigated. In which direction they have diverted those accounts. And if your lordship grants interim protection, lordship, those things will not come up, lordship, at this stage. And my prayer is that, lordship, as my learned senior friend has submitted that within 10 days that account audit report will come. So lordship may wait for 10 days, and in the meantime, they can also appear before the investigating officer.
My lord, I am ready, my lord. I am ready, my lord.
That will wait whether that contradictions, whether that is there in their statement and case that your lordship will be.
That may, my lord, they have to be given interim protection. One person is already on.
No, then during this period, they will cooperate in the investigation. If you get difficulty in the investigation, you can inform this court for cancellation of interim bail.
Instead of disposal, lordship, my prayer is that he may be protected and up-to-date report may be called, because.
Okay, heard in item number 40. In whether a common order can be passed.
Common order may be passed, my lord, mentioning both the case number.
No, both the cases. You are not pressing I, objecting to I, don't object. I am disposing.
He is saying, my lord, all right. But directly, he is not, my lord, complaining.
Okay, that we are not deciding now.
My lord, keep it.
We are leaving that
My lord.
issue. Heard Mr. A.K. Azad. Heard Mr. A. Ahmed. Learned counsel for this interlocutory application. Learned counsel for the applicant who prays for impleading the applicant as a victim. Applicant as respondent number 2 in AB case number 2060/2024. Stop. Also learned counsel for the petitioner, Mr.
C. Bora.
J.C. Bora, as well as Mr. R.J. Borwa, learned additional public prosecutor. Learned counsel for the petitioner, namely Mr. J.C. Bora, has conceded to the prayer on the ground that the counsel for the applicant, Mr. A. Ahmed, may be allowed to assist the learned additional public prosecutor only. Stop. As the petitioner has conceded to the prayer made by the applicant. Stop. This application, interlocutory application, is disposed of with an observation that instead of impleading the applicant as a party, the counsel for the applicant may assist learned additional public prosecutor in the connected bail application, anticipatory bail application. This interlocutory application is accordingly disposed of. In AB 2060, that is item number, no, both the cases common order. These two bail applications, namely AB 2132/2024, as well as AB number 2060/2024, has been filed by the petitioners, namely who is the petitioner of 39? Namely Gyasuddin alias Gyasuddin Ahmed and Abdul Mateen, respectively. The petitioners are the secretary and the president of Nagabandha Gaon Panchayat Samabhay Samiti Limited. Stop. Both the petitioners have filed the respective anticipatory bail applications, apprehending their arrest in connection with Lahori Ghat PS case number 142/2024. The gist of accusation against both the petitioners is that on 9/7/2024, the Assistant Director, Food and Public Distribution and Consumer Affairs, Morigaon, had lodged an FIR before the officer in charge of Lahori Ghat Police Station, inter alia, alleging that both the petitioners have been involved in malpractices of midday meal rice scheme, as well as Pradhan Mantri Garib Kalyan Annapurna.
My lord, প্রধানমন্ত্রী গরিব কল্যাণ অন্ন যোজনা।
Anna Yojana, as well as misappropriation of GPSS. What is this GPSS? Gram Panchayat.
Panchayat Samabay Samiti.
Gram Panchayat Samabay Samiti funds. Stop. Learned Senior Counsel, Mr. T.J. Mohanto, Learned Senior Counsel for the petitioner, has submitted that the filing of the FIR against the petitioners was preceded by an inquiry conducted by who conducted the inquiry?
By the assistant director himself.
By the by the first informant himself. And a show cause notice was also issued to both the petitioners. Though the petitioners had replied to the said show cause notice, however, Learned Senior Counsel submits that the license of Messrs. Nagabandha Gram Panchayat Samabay Samiti Limited has been cancelled. He also submits that as regards the allegation of misappropriation of funds is concerned, same can be ascertained only after completion of the internal audit or what?
Official audit, my lord. It is,
Of
my
the-
lord, as per rule, my lord, 14 of the, my lord, there is the official audit.
Of the official audit, which is likely to be concluded within a period of 10 days from the date of this order. Therefore, he submits that after the completion of the audit, a report may be called for from the investigating officer regarding the audit, which would make the things clear. And during that period, they may be allowed to go on. They may be allowed some interim protection. Stop. Learned Additional Public Prosecutor, Mr. R.J. Borua, submits that this case involved embezzlement, allegation of embezzlement of huge amount of public money. However, he also submits that as the final audit is likely, official audit is likely to be completed within a period of 10 days from the date of this order, the report regarding audit may be called for from the investigating officer, and he has no objection if
My objection may be recorded because there is objection from the investigating officer.
and report regarding may be called for. However, he objected to the grant of any interim protection during this period to the petitioners. Stop. I have considered the submissions made by Learned Counsel for both the sides. Considering the fact that the license of the petitioners Samabay Samiti, namely Nagabandha Gaon Panchayat Samabay Samiti Limited, has already been cancelled, and the godown has also been seized, and the godown containing the rice of midday meal as well as Pradhan Mantri Gramin Kalyan Anna Yojana has already been seized, and as the allegation regarding misappropriation of GPSS fund would be clear only after completion of official audit, which is likely to be completed within a period of 10 days as informed by Learned Senior Counsel for the petitioners. Stop. A report to that effect would be helpful for consideration of the instant bail applications. Hence, the investigating officer of the Lahori Ghat PS case number 142 of 2024 is directed to submit a report regarding the official audit regarding the allegation of embezzlement by the present petitioner of GPSS fund after completion of the official audit in that regard. Stop. As the completion of official audit would require some time, that is minimum 10 days, the petitioners are directed to cooperate in the investigation during this period. Both the petitioners are therefore directed to appear before the investigating officer of Lahori Ghat PS case number 142/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the said stipulated period of time, in the event of their arrest in connection with Lahori Ghat PS case number 142/2024, both the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again after.
We return the case there, my lord, for the purpose of after the.
Yes. Let the case diary be returned back to be called again after updation, along with the report of the investigating officer as directed herein above. Let this case be listed again. When should we list it?
On 26 or 27, my lord.
On 27th of September 2024. Yes.
May I please, your lordship? My lord, 482 application, lordship. FR is at page 9, lordship.
482 anticipatory bail.
482 BNSS, lordship.
No, 482 is. Oh, yes.
BNSS, lordship.
Anticipatory bail.
Yes, lordship.
Where is the FR?
FR at page 9, lordship.
What is your name?
Mujibur Rahman, lordship.
Only one petitioner.
Yes, lordship. I am appearing for petitioner accused number 1.
There are allegations against you in the FR. What
As
is
well
there in the
as well
FR?
as 164 also, my lord.
What is your submission?
My submission is, lordship may kindly see annexure 2 at page 13.
Annexure 2 at
page 13, lordship. This annexure 2 has a bearing in lodging this FIR, lordship. Page 13, lordship.
Yes. What is this? Promissory
Paragraph
note.
number 1 may kindly be seen, lordship. That I am a soldier of labor and used to supply my labor to the brick industry farm and work with them in several places, and as such, I received rupees 1,20,000. This is Mujibur Rahman. This Mujibur Rahman is the husband of the informant. And I am also Mujibur Rahman, lordship. I am petitioner. I am also Mujibur Rahman. 1,20,000 from Mujibur Rahman, son of so-and-so, 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 on condition of supplying 4 numbers of loading labor to him within 2 months and received the said money in advance against 4 laborers
if I default to provide labor within 2 months from today, then I shall bound to return back the aforesaid advance money in cash to him, failing which I shall be liable to deliver my motorcycle to him against aforesaid money, vide motorcycle number so and so, so and so. Then if I default to refund rupees so and so to him, either in cash or deliver by aforesaid motorcycle to him, I shall bound to be punished in the eye of law. And this was done on 1/11/23. This is prior to the lodging of the FIR lodging. This was signed prior to lodging the FIR lodging.
Okay.
And this Mujibur Rahman, husband of the informant, he could not supply the labor in time. Hence, the petitioner pressurized him to return back the money, 1,20,000 lordship. He also had taken the motorcycle of the informant, Sarnal, but later on it was released to him. And as the petitioner pressurized for that money, this FIR was lost lordship.
Okay, that is.
And there is delay in lodging the FIR for 40 days lordship. Lordship may kindly see
40 days.
40 days.
Why this delay? Mr. Borwa,
40
you
days delay.
look into the CD. I'll come to you. Yes, then 40 days.
40 days delay lordship. Incident as per allegation took on 14/1/24 and the FIR was lodged on 24/2/24. 40 days lordship. There is no reasonable explanation in the FIR as to why this delay was occurred. Meaning thereby, they lodged this FIR in a pre-planned manner. To my instruction, lordship, now the informant and her husband is approaching for settlement of the issue and demanding for money. That is also not agreed by the petitioner because he is not involved in that case, lordship, in the allegation.
Yes.
So it is a clear case, lordship, that
Not so clear. Any explanation for delay?
Yes, my lord, in the FIR itself, my lord. Lordship may come down below, my lord. My lord, on 14/1/2024, my lord, he commits the offense, my lord, first initially. That is, I am reading the vernacular, my lord.
Yes.
Then, my lord, lordship may kindly see little down below, my lord. পিছদিনা ৰাতিপুৱা ভাটাৰ পৰা ঘৰত যাব খোজাত 1 নম্বৰ আৰু 2 নং আসামী, my lord. Against my lord 21 number, there is no such allegation, my lord. মোক উক্ত ভাতাত দিনত ইমান দিনে আবদ্ধ কৰি ৰাখে ও বাহিৰত যাব নিদিয়ে, মানে যোৱা 20/1/2024 তাৰিখে মই কিবা কিবি কিনিবলৈ বজাৰত যাওঁ যদিও আসামী ধৰে মাৰুতি গাড়ীৰে মোক বজাৰৰ ৰাস্তাৰ পৰা অপহৰণ কৰি আনি আকৌ ভাতাত আবদ্ধ কৰি ৰাখে। প্ৰাণৰ ভয়ত মই 21/1/2024 তাৰিখে নিজ ঘৰত পলাই যাওঁ, মানে।
Even then 34 days delay, lordship. From, if we count from 21/1 instead of 14/1, 34 days delay.
Now, what other materials are there?
My lord, 160%, my lord.
Apart from that?
Apart from that, my lord, the other witnesses also, my lord, supported, my lord. Witnesses examined during the investigation.
Lordship, informant definitely implicate him because he has lost the affair.
No,
she has. She will support her case.
Apart from informant.
Apart from informant, my lord.
That she was.
Yes.
Detained in the Ita brick lane.
Yes, my lord.
That may be for the reason that.
My lord, hears, my lord. She heard from the person who has given a statement, my lord. She heard from the, my lord, victim, my lord. Because this is the, my lord, incident, my lord, nobody has seen, my lord. Otherwise, there would have been eyewitnesses, my lord.
Yes.
She might have been obstructed from moving from the Bhata only to recover the money. That may be their lordship.
Okay,
to
that is enough.
The husband
But-
statement, my lord, he does not stay along with his wife. My lord.
You restrained her
No,
from moving out from.
No. If is assumed to be truth, the FIR lordship, that may be done for recovery of the amount. Otherwise, there is nothing lordship.
Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. R.J. Barwa, learned additional public prosecutor. This application under section 482 of the BNSS 2023 has been filed by the petitioner Mujibur Rahman, who is apprehending his arrest in connection with Jogi Gopa PSK. She has stated on oath
164, my lord.
Jogi Gopa PS case number 40/2024 under section 376, 363, 324, 342. Instead of 324, 342. 506, 34 IPC. The gist of accusation in this case is that on which date the affair was lodged?
24 to 24.
On 24/2/2024, the victim lady had lodged an FIR before the officer in charge of Jogigopa Police Station, Inter, stating that she is a daily labor woman working in Milan brick industry situated at Dalani Bill at Talipara. She has alleged that on 14/1/2024 at about 11:30 p.m. the petitioner trespassed into his room and committed rape on her against her will. The petitioner also threatened her to kill by keeping a dagger on her neck, and also did not allow her to go away, to come out of her room, and kept her confined there. It is also stated in the affair that somehow the victim managed to escape from the brick kiln on 21/1/2024. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the petitioner in the affair are false. Learned counsel for the petitioner has also submitted that on 1/11/2012, 23, an agreement was reached between the husband of the informant and the petitioner to the effect that who received money? Who is this Mujibur?
Husband of the informant lordship.
To the effect that he would provide 4 numbers of laborers for loading purpose to the present petitioner, and in lieu of that he received a sum of rupees 1,20,000. Stop. It is submitted by learned counsel for the petitioner that the informant's husband failed to abide by the agreement and provide the laborers as agreed to by him. And therefore, it is also submitted that the husband of the petitioner, husband of the informant, also did not return back the money to the petitioner. And therefore, the husband of the petitioner has used his wife to lodge a false complaint against the present petitioners. 183 statement. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner on the ground that the petitioner has implicated that the victim has implicated the present petitioner in her statement recorded under section 164 of the CRPC. Stop. And considering the nature of offense involved, he submits that the prayer for bail should be rejected. I have considered the submissions made by learned counsel for both the sides and have perused the case diary which is available on record, which was called for in connection with this case. On perusal of the statement of the victim woman, it appears that she has categorically implicated the petitioner of having committed forceful sexual intercourse with her in absence of her husband. Stop. It also appears that the investigating officer has recorded the statement of some other independent witnesses who have also made incriminating statement against the present petitioner. Stop. Considering the nature of offense involved in this case, as well as incriminating materials available against the present petitioner in the case diary, this court is not inclined to grant bail to the petitioner at this stage. Hence, the prayer for a grant of anticipatory bail is rejected. Send back the case diary. This anticipatory bail application is disposed of.
Obliged.
Also, I'm sorry to interrupt, my lord. Item 57 in the morning, Lordship is granted bail, my lord. Lordship is directed in, my lord, he will have to have the bail from the CJM Vishwanath. It will be SDJM Gopur. I have inquired with the advocates there. Records are in SDJM. Item 57.
Item 57, SG, instead of CJM Vishwanath, it will be SDJM Gopur.
Gopur Vishwanath. I love you.
May I please, your lordship? My lord, in this case, my lord, respondent number 2 died, your lordship. And respondent number 3 is the victim. And for respondent number 3, lordship.
You have appeared.
Lordship.
Who is 2?
2 is informant, father of respondent number 3, your lordship. And respondent number 3 is the victim. She is the wife of the petitioner. My lord.
What for this?
Lord, some kidnapping case was registered.
This is in orders column. We'll fix it for admission hearing.
My lord, good. Strike. Respondent number 2 may kindly be strike out.
Heard, Mr.
My lord, interim prayer may kindly be considered. There is no interim, your lordship.
Heard, what is your name?
A. Rahman.
heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, no, Mr. P. U. Bhattakur, learned additional public prosecutor, appearing for respondent number 1, State of Assam. Also appeared, also heard Mr.
N. Alamarki.
N.
Alamarki.
Alam Ali, appearing for respondent number
3.
Respondent number 3. Stop. On perusal of the office note dated 28/8/2024, it appears that the notice issued to respondent number 2 has returned back with an endorsement within inverted comma, deceased, comma, returned to the sender. Whether respondent number 2 has died, you
Died.
must be knowing. You
Yes,
must
sir.
be knowing because Mr. Ali, who is respondent number 2? Your father,
Lordship.
whether he is alive or died.
Right, Lordship.
Learned counsel for the petitioner has also, learned counsel for respondent number 3, who is the victim woman and who is the daughter of respondent number, who is the victim woman and who is the daughter of respondent number 2, has also confirmed the death of respondent number 2. Stop. Learned counsel for the petitioner has submitted that in view of the facts and circumstances of this case, the name of respondent number 2 may be struck off from this case. This criminal petition, the prayer is allowed. The registry to strike out the name of respondent number 2 from the cause title. Stop. Let this case be listed for admission hearing on when? Next week.
Interim period may can be considered.
On next date we will consider, not today. On 29/2024, the prayer for interim relief shall be considered on that day. To Agor Kesar, E.G. Mohanto Jyote Pierpun. Item number?
49, my lord. I'm
Yes.
going for the respondent, there's a leave petition filed regarding seeking leave to file an appeal against Equitable, my lord. NIA case, but they are not present today.
Negotiable instrument.
Negotiable instruments acquitted. I was acquitted, now they are seeking leave to file an appeal, my lord.
You are opposing.
They are not there, my lord. So
Okay. None appears for the applicant on call. Heard Mr. S. Nawaz, who is appearing for respondent number, sole respondent.
respondent, madam.
Sole respondent. Stop. Let this matter be listed again after 2 weeks on a date to be finalized by, fixed by registry.
deeply obliged.
May I appeal? This matter has come up for suspension of sentence and grant of bail, Lordship. Can it be taken up day after tomorrow, Lordship?
Yes, on. Heard Mr. A. Azad, A. Ahmed, learned counsel for the applicant. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Let this case, on the request of learned counsel for the applicant, let this case be listed again on 13/9/2024 for in orders column.
Lordship, for the petitioner, for the office note, your lordship, the notice issued to the respondent number 2 has returned because with the remark that the addressee could not be located. But the address which the notice was sent was the same address where the complainant.
This is a Pocso case.
No, your lordship. No.
NIK.
Oh, NI.
420.
Then notice have to be served.
420. The 420, the cognizance was taken.
This is for what? Washing off?
Washing of complaint.
Washing of complaint.
Complaint.
406 complaint.
The cognizance was taken only under 420. And there was a complaint case number 22/2022. About it.
You take fresh steps. By which mode?
Can
By,
be allowed to take to electronic.
no, by registered post, as well as through the SDGM Bokaghat. Because he is coming to the court.
Yes, yes.
In court, he can be heard, Mr. What is your name?
GR Datta.
GR Datta, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. On perusal of the office note dated 9/9/2024, it appears that the notices sent to respondent number 2 has returned with postal remarks within inverted comma. Addressee cannot be returned. Addressee cannot be located, comma. RTS inverted comma close. Stop. At what stage the case is pending?
Interim protection was given in the first day.
It is stayed.
Yes, your lordship, stay.
The petitioner, in view of above, the petitioner is directed to take fresh steps to the fresh steps for issuance of notice upon the respondent number 2 by registered post with AD, as well as through the learned subdivisional judicial magistrate Bokaghat. The petitioner shall take steps for issuance of notice within 7 days from the date of this order, returnable on 1st of October 2024. The interim order passed earlier shall continue till next day.
May I please, Lordship? Lordship, notice has been served already.
From where are you saying?
Lordship,
Office note says that you have not even taken steps. You have not taken steps for issuance of notice.
Lordship, already step has been taken, Lordship.
But
I
office
have
note
been-
says
Lordship.
heard Mr.
SH
SH
Soikia.
Soikia. Learned, this is a NI case.
NI case.
Learned counsel for the petitioner. On perusal of office note dated 30/8/2024, it appears that the petitioner has not taken steps for issuance of notice as no notices have been received by the concerned section of the registry. However, learned counsel for the petitioner has submitted that the petitioner has taken steps for issuance of notice on the sole respondent in pursuant to the directions of this court. And the said notices were received by the concerned section of the registry on 10/9/2024. In that regard, he has also produced an acknowledgement receipt to that effect. Stop. Here, put their photocopy rakhibo. Let a photocopy of the same be kept in record. The registry is directed to verify the same and put up proper office note after verification regarding, after the said verification regarding the service of notice on the respondent. Let a copy of the acknowledgement receipt produced by the petitioner be kept in the case record after marking it as X. You take it back, keep a photocopy here. Let this case be listed again on in the next week. That is in the next week on a date to be fixed by registry with the appropriate office note in that regard. Itu ghurai din. Photo.
Wait, please, my lords. My lords, in this matter, report of service is still awaited upon respondent number 2. Lords.
What should we do? Should we await?
Yes, my lords.
What is your name?
T. Das, my lords.
Heard Mr. T. Das. On perusal of the office note dated 9/9/2024, it appears that neither the AD card nor the unserved notice in respect of respondent number 2 has been received back by the registry. Stop, await further. Is there any interim?
No, my lords.
Await further. List this matter after 2 weeks on a date to be fixed by registry. None appears for the petitioner on call. Let this matter be listed in the next week on a date to be fixed by registry.
Otherwise, also, Lordship, the matter has been ended up with FR, Lordship.
Oh, is it?
Yes,
Then on the next week.
Lordship.
Okay. One line. Heard Miss S.H. Bora, an additional public prosecutor, who submits that the investigation has been completed and final report has been filed in this case. So let the matter be listed again in the next week on a date to be fixed by registry.
Lordship.
May please, Lordship. Lordship, in this case, Lordship, the petitioner has challenged the FIR registered as Borsuk PS case number 193/21 under section 294A 507 IPC radio section 111(1) of Prevention of Animal Cruelty Act. In this case, Lordship, may I pray that let the matter be fixed on a hearing day, Lordship, and on last occasion, the court has asked the NDPS to submit, provide a status report of the case. And I am not sure whether the charge sheet has been submitted or FR has been submitted till date.
Lordship, so far as my information is concerned to this regard, Lordship, charge sheet is yet to be filed. And in the earlier occasion, up-to-date status report was called for. So that is also not before us, Lordship. So let's fix the matter after 2 weeks.
We'll admit it for hearing and fix it.
Lordship.
in hearing column. Today it is in admission.
Lordship.
We'll admit it. Heard Mr.
SN Krishna Tra.
S.N. Krishna Tre, learned counsel for the petitioner. Also heard Miss S.H. Bora, learned additional public prosecutor. Learned counsel for the petitioner submits that this matter may be listed on a hearing day. So on the other hand, learned additional public prosecutor has submitted that where is the original case diary? It has been returned back.
Lordship.
Earlier occasion, Lordship, the case diary was called for and the case diary was tagged in with the case record. The matter has not listed for many days. Then on 24/7, it came to the knowledge of learned PP as well as us that the original the cost title in the cost is shown as LCR. So upon verification of case record, it is found that original case diary was in the case record. Thereafter,
It is not there.
no, thereafter a judicial order has been passed to send back the CCD.
Okay.
Then KCD was sent back.
Should we call for again a status report?
Lordship, along with the up-to-date status report.
So,
Lordship, since there is no stay, I am also suffering. I could not travel. So it is
you
also-
suggest we will fix it a fixed head instead of 2 weeks, we will give a fixed date.
Lordship,
of hearing.
that will also do.
Let a status report as regards the state of investigation in respect of Gorsuk PS case number 193/2021 be called for. Learned additional public prosecutor is requested to produce the status report on the next date fix. Let this case be listed again. No, this criminal petition is admitted for hearing. Let this case be listed for hearing on which date?
Lordship, 23,
20?
23.
23 is Monday,
That is your 24th.
24th,
Lordship.
24/9. 20.
Lordship.
Deeply Lordship.
May please your lordship, here my lordship, soliciting the charge my lordship. Here my lordship, petitioner number 2 already died, my lordship. So raised allegation will be, here my lordship, against petitioner number 1, my lordship.
What is this?
Petitioner number 2, my lordship died.
Okay.
Now, allegation against will be petitioner number 1, my lordship.
What is this charge sheet?
Yes, sir.
Okay, what is the status of the case?
It is in appearance stage, my lordship.
Is there any stay?
No, my lordship. The case is fixed day after tomorrow, my lordship, that is on Friday. For appearance stage.
Who is for the respondent? How many respondents are there? Now, what should we do today? What should we do today? Should we hear it and dispose it off? Or what should we admit it and fix it for hearing on the next day?
As your lordship,
We'll
admit the
we
matter and
will
accordingly.
mention regarding death of the respondent number 2. Petitioner number 2. What is the matter actually?
Matter against 366 to 94 and 506, my lordship. The informant daughter was lured by the petitioner number 1 as he is 17.5 years age of dialysis incident. And then my lordship.
What is your ground?
My lordship, as the petitioner, it is completely a lie.
You are opposing?
Yes, my lord.
You're opposing?
Yes, my lord.
Then we'll admit it and fix it. We'll reflect the death regarding death of the
Lordship, that can be.
LCR is there.
Yes, your lordship.
Okay.
Scan copy is there, your lordship.
Third, Miss
Be Bhuya, your lordship.
B. Bhuya, learned counsel for the petitioner, also Miss S. H. Bora, learned additional public prosecutor, as well as Mr. R. Day, learned counsel for appearing for respondent number one. One. Learned counsel for the
No, but respondent number two, Milo. Respondent one is the state.
respondent number two.
One is the state, Milo.
Respondent number two, stop. Learned counsel for the petitioner has submitted that the petitioner number two has died, has passed away on 24/10/2023. And in support of her submission, she has produced a photocopy of death certificate. Stop. Let the said copy of death certificate be kept in the case record. Same is marked as X. Stop. Learned counsel for the petitioner has also submitted that the petitioner number, name of the petitioner number two may be struck off from the cause title of this case, as he has already passed away. The prayer is allowed. Registry is directed to strike out the name of respondent number two from the cause title. This criminal petition is admitted for hearing.
Till then, my lordship, stay maybe. Yes, the case is
Only
fixed
thing the
for
lordship may
appearance.
fix the matter after immediate after the petition, since the LCR is already there.
Yes, we can hear it and
The family
dispose it.
dispose of it unless
Because,
we-
because my lordship cases, though the case is pending, the law court below, and we have to appear, my lordship. That's why my lordship, if the
You appear. Now, what is the ground?
Crown, my lordship, as the 366, this is a completely a love affair, my lordship. And the 161, 164 statement also there, maybe in the scan copy, my lordship. Here he categorically stated that this is completely a love affair, my lordship. See herself came with
On
the
next date, we will consider your prayer. We will try to dispose it off. Let this matter be. When do you want it for hearing?
any date
Suggest a date. Hearing date.
after 20, my lordship. After 20th September.
Let this case be listed. The scan copy of the trial court record has already been received. Let this be, whether the case diary is there or not.
Their option.
Okay.
Cognizance is already been taken. Lordship.
Let this case be listed for hearing in the third week of September on a date to be fixed by registry.
Interim will be considered in the next date, your lordship.
lordship is disposed of the next
Let me be silent in here.
Oblige, your lordship.
In this matter, your lordship, as per the order by the honorable court, it has granted interim protection subject to the condition of 20% deposit to be 20% of the amount of compensation to be paid by the petitioner. Your lordship. But I have contacted several times, your lordship, to my client, but he is not responding, your lordship. So.
Then we will not admit it and dismiss it.
No, your lordship. Right, your lordship, I may be allowed some more time, your lordship. Subject to the, and with the condition that if he doesn't pay within that period, your lordship.
My lord, on 29/8/2023, lordship, while issuing notice, lordship, the order was suspended, lordship, subject to payment of 20% of the compensation amount. Thereafter, lordship, on 26/22/2024, lordship, this honorable court directed to deposit on or before 11/3/2024, lordship. But that was not deposited, and on 11/3/2024, lordship, my learned friend absent, lordship, none appears. Then on 3/4/2024, they have taken time, lordship. So, and 10/6, ultimately, lordship, on 6th and last date, lordship, they again, lordship, absent, lordship. So in such a way, lordship, they have repeatedly taken time, lordship, but subject to payment of that 20% compensation, lordship, Lordship, I may be make a submission, Lordship, that that interim order may be vacated, Lordship, because they have not
Yes. It is
Lordship,
it
following
is-
the direction, Lordship, of this.
Interim order has to be vacated.
On the next day.
No,
Your
no,
Lordship,
today
because
we are vacating
because
it.
there was
If you submit
10/6,
next
Your
day,
Lordship.
you pray for interim order again on next day. But not indulgence to such an extent. We are vacating interim order. Heard,
That is up to you, Lordship.
Mr. What is your name?
K. Mira, Your
K. Mira, learned counsel for the petitioner. Also heard Mr.
NH Borbuyal.
N.H. Borbhuya, learned counsel for the respondent.
Respondent number 2, Lordship.
Respondent number 2. State is also party.
Yes, Lord.
Also heard Ms. S.H. Bora, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 26/2/2024, the impugn order. No, by order dated 15/2/2024.
Lordship, in case number 10, item 10, Your Lordship, it is order dated 29/8/2020.
We are taking up which item?
Item 10, Your Lordship. Criminal division petition number 352/2020.
10 and 11 same method.
Same parties, Your Lordship. But
In-
two different cases.
Ten 29/8/2023 and 11/11/9/2023, Lordship.
In criminal petition number common order होगा इसमें. In criminal revision petition number 352/2023 by order dated 15/2/2024. No, by order dated 29/8/2023. The operation of impugn judgment dated 23/6/2023 passed by learned additional session judge within bracket FTC Kachar in criminal appeal number 1/2020 was suspended subject to deposit of 20% of the compensation amount by the petitioner. Similarly, by order dated after full stop, similarly in criminal revision petition number 365/2023 by order dated, which order?
11/9/2023.
11/9/2023. The operation of impugn judgment dated 23/6/2023 passed by learned additional session judge Kachar in criminal appeal number 2/2020 was also suspended subject to payment of 20% of the fine amount by the petitioner before the registry. Learned counsel for the petitioner has submitted that in both the cases, petitioners has not yet deposited the amount as directed by this court. He prays for some more time for depositing the said amount. On the other hand, learned Mr. Borbhuya, learned counsel for the respondent number 2, has submitted that the petitioner has been given sufficient indulgence by this court, and in spite of granting several opportunities, he has failed to deposit the amount as directed by this court. Hence, he prays for vacating the interim orders passed by this court in both the cases. Stop. On perusal of the record, it appears that the petitioner has that the impugn orders in both the cases were stayed subject to payment of the 20% of the compensation/fine amount. However, as the petitioner has failed to deposit the said amount, in spite of getting several opportunities, no further indulgence may be granted to the petitioner. Hence, the interim order dated 29/8/2023 passed in criminal petition number 352/2023, as well as the interim order dated 11/9/2023 passed in criminal revision petition number 365/2023 are hereby vacated. Let this case be listed for, hereby vacated. Now what will happen for hearing?
My lord, I think, my lord, hearing is not at all required, but a date may kindly be fixed, Lord.
Let this case be listed.
Otherwise, your lordship also required to dismiss it because this is a concurrent finding, lordship. But without going to the merit, lordship, I think. I may proceed to recover the amount, lordship, through.
No, there is no bar now.
Yes, lordship.
Let this case be listed again after 2 weeks on a date to be fixed by registry.
One prayer, your lordship, prayer of interim prayer may be considered on payment of the, if
Now there is no interim prayer, it has been vacated.
on
You have to
payment, your
make a fresh prayer for grant of interim.
My
Because
lord,
the
after
inter-
depositing, my
After
lord,
depositing
my
your-
friend may file
that
a IL, lordship.
that option is always available.
Yes.
But the interim which was granted earlier is vacated. You have to file a fresh IA for interim.
All right.
Lordship. My senior having some difficulty in his eyes and he's undergoing treatment, Lordship. Therefore, I'm praying for an adjournment, Lordship. Earlier, I came to mention, Lordship.
Or you mentioned in the morning
Lordship.
without informing the other side.
I tried to contact them, but
Any objection?
Lord,
Eh,
they have not we have not getting any communications. This morning we are waiting for this matter,
tried,
my lord.
Aye.
And this is a disjournment of check case, NI Act, Your Honor. And there is an interim stay order by this honorable court. This stay order was, my lord, on 23.
No, but
11,
today
23,
council
my lord.
is ill. Council is indisposed. So we are fixing it next
Let a
week,
date-
next week.
The next week, Your Honor, is suitable date, my.
Heard Mr.
MHL.
M.H. Ali, learned counsel for the petitioner, also heard Mr. B.K. Jain, learned counsel for respondent number 1. Learned counsel for the petitioner has submitted that the conducting counsel, Mr. A. Sahad, is indisposed, and on that ground he prays for an adjournment. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed again in the next week on a date to be fixed by registry.
My Lordship.
Interim shall continue till next day.
Lordship, the case diary and the police status report was not received from the Bosishwar police station.
Lordship, here the matter is ended up in the FR, Lordship.
FR,
Yes.
finish. If FR has been submitted, you don't have a case. You don't have grievance. What do you want now?
Any date may be fixed. We need to check out.
Okay.
So I have got the number, Lordship.
Okay. Heard, Mr. What is your name?
Eka Koti, Lordship, on behalf of the.
We can dispose it of today if you want,
Yes.
because if they, or let them find out. Because even if
Because no notice has been written.
FR has been submitted,
Lordship.
notice will go to the complaint.
Let them find.
Heard, Mr. What is your name?
Eka Koti, Lordship.
Heard, Mr. Ekakoti, learned counsel for the petitioner. Also heard, Miss, what is your name?
P. Chaudhary.
P. Chaudhary, appearing for this. No, heard, Miss S.H. Bora, learned additional public prosecutor, as well as Miss P. Chaudhary, appearing for respondent number 2. Respondent number 2. Learned additional public prosecutor has submitted that the investigation in
Vasishta PS case number.
which Vasishta PS case, Vasishta PS case number 325/2021 has already been completed and final report has been submitted in this case. Stop. Bearing final report number
Right, FR number 2882.
2882
/2023,
dated
dated 30/12/2023.
learned counsel for the petitioner has prayed for, though it appears that the petitioner may not have any grievance further as the final report has been submitted, but learned counsel for the petitioner submits that he may have to take some instructions from the petitioners and prays for some more time. Moreover, learned counsel for respondent number 2 has also submitted that the complainant has also not yet received any notice after submission of the final report. Stop. In view of above, let this matter be listed after 4 weeks on a date to be fixed by registry.
May I please, Lordship? Lordship, 482 application for quashing the FIR as well as the charge sheet, Lordship. Lordship, it is a case under section 498A, Lordship. So, Lordship, before going through the.
Perhaps time will not cover, Lordship. We have free, Lordship, short date may be given, Lordship, other. Transfer to short issues involved.
Transfer petition. This is a NI Act.
Yes, my lord.
You have not appealed from which court's order?
My lord, it is from your additional chief judicial magistrate Kasar.
So appeal lies before the sessions court. How you can come to this court?
Against acquittal, my lord.
Oh, against acquittal. Then there has to be a leave application.
Already, my lord, ordered, my lord, allowed.
Leave allowed.
Yes.
Okay. This is an appeal under section 378(4) of the Code of Criminal Procedure filed by the appellant Ranju Yadav, impugning the judgment and order, judgment dated 17/12/2023.
That was
7/12/2023, passed by learned additional Chief Judicial Magistrate Kachar, Silchar in NI case number 32/2018, whereby the respondent number 1 was acquitted of charges under section 138 of the NI Act. Yare Heko. I. The leave for filing this appeal has already been granted to the petitioner by order dated 26/6/2024, passed by this court in IA within bracket criminal 234/2024. Stop. Issue notice to the respondents. Since Mr. R.J. Bora is appearing for respondent number 2, no formal notice need to be sent to respondent number 2. As regards respondent number 1 is concerned, the appellant shall take steps for issuance of notice to respondent number 1 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the case record of NI case number 32/2018 be called for from the Court of Learned Additional Chief Judicial Magistrate Kachar. This appeal is admitted. Stop. List accordingly.
After vacation.
After 4 weeks,
Deep notice.
finish. Time is over. Now regarding leftover will be leftover unless there is some urgency. If someone has very urgent matter, you may mention. Yes, Mr. Das.
Item alert 19, my lord.
You have anything? You have anything?
Item 63. Lord, this case is pending for last 3 years and all during 3 years, several times they have been listed, but the time does not permit, my lord. This case may be fixed on 19th of September, my lord. Because 2 cases are stayed in Hosai, my lord. And the chief magistrate, principal magistrate of juvenile justice is always taking my client to task that you have not been able to bring any order from the High Court. You have got it, got the proceeding state.
Okay. 63. Who is for the other side?
I go on.
Who is for the other side? Item number 63. This item number 63. Heard Mr. B.C. Das, learned counsel for the petitioner. This matter could not be taken up due to paucity of time. Let this matter be listed again on 19th of September 2025. Yes.
Item 19, my lord.
What
The
is
dispute between the husband and wife, my lord, and they are ready to settle the matter, my lord, through mediation, my lord.
now? What is your prayer?
Kindly see, my lord, on last occasion, my lord, both the parties are directed to produce the, my lord,
Payment
regarding
slip, my
payment, my lord.
You have settled the
Yep.
dispute.
No, my lord, I have not paid the entire amount, my lord.
Yes, my lord.
And my lord,
Payments.
No,
under
then,
DB Act, my lord.
then not now. What do you want to mention? Otherwise, it will be listed in due course.
But there is a urgency, my lord. He has not paid the any amount under the DB Act, my lord.
Already, my lord, 3 lakhs has been paid, my lord.
It is just,
Item number 19.
Where is the order,
Item
my
number
lord?
19.
I have also certificate copy, my lord.
Due to paucity of time, this matter could not be taken up. List this matter after 1 week. After 1 week on a date.
19, my lord.
19 again, same scene will be there. If everything is fixed on 19. On a date to be fixed by registry. Registry will finalize.
If it is not fixed, my lord, then it will be difficult for listing, my lord. Matter is very urgent, my lord. As because, my lord, NBW has been issued, my lord, against the petitioner, my lord.
And another criminal revision also pending, my lord, fixed along with that revision, my lord.
When?
Regarding challenging the order passed by the
Enhancement of
family
the-
court. Family court.
Fix on 26. 26.
Along with my lord, criminal revision petition number 573, my lord.
No, that is not before us now.
My lord.
For that, a separate mentioning has to be.
My lord.
Lordship, I beg to mention, item number
All right.
20. It is a criminal appeal against conviction for 3 years against Pocso Act. So, on 20th of September is the last date of remaining on previous bill. So it may be listed before
19. Item number 2019. Councilor, what's your name?
Yes, sir.
Yes, ma'am. Council.
Problem. May I please, your lordship. My lord, I beg to mention item 23. My lord, the last week is in the honorable court passed the interim order till returnable date, that means till today, my lord. So interim may be continued.
Item number 23. To be listed after 2 weeks on a date to be fixed by registry. Interim shall continue till next day.
Till disposal, my lord. Otherwise, in sometimes matter not listed.
No, till next day. Not till disposal.
Obligation. After 2 weeks, my lord.
After 2.